I'll present evidence for this.
Yes, so those are actually. Was there, was there a criminal complaint filed?
Ms. Carver swore out a criminal complaint, basically her allegation are that Mr. Carver, somebody went through his Gmail account and hacked into all of her Facebook and things of that nature. She said she can't even access her pictures at this time.
Did the district court take any action in this case?
It's still pending.
I don't think we've not even been arraigned on it yet.
Is it, so it was by criminal complaint,
Yes.
not, there wasn't a warrant, so there was a civil summons.
No, it's,
It's a criminal summons.
I don't know.
No, he was, there was an arrest warrant issued.
Sir?
Yeah.
Well, I don't know. Has there bond conditions on it or anything?
It was $500 cash, no other conditions. I have to look on it. Anything about no contact?
Yeah, there was no contact.
We'll just parallel what they put on that, which they add to your bond here, that can, the same condition you have in district court, in case that gets dismissed or takes a while or something like that. A word to the wise is sufficient. I don't want you to shake your head up and down. I don't want you to make any admissions. You got a lawyer here today. But if you did do this, it was a poor mistake. If you didn't do it, you know what you're dealing with. Either way, you need to be very careful to avoid any contact. You understand what I'm saying? You hear that, Mr. Cross?
Absolutely.
Okay, what do you want to schedule here? Is this scheduled for anything else?
We had a pre-trial. Mr. Cross said at a conference, he said he couldn't be there that day. I don't know if they're ready to discuss this case or not, but if not, then I'm gonna be getting the trial date next month.
Yeah, I thought we were gonna take it up in November. My note said we were gonna have a
We got
pre-trial in
negotiations
November.
today, October 27th at 1 o'clock.
And we're gonna
27th.
try to have some
Be there as part of your bond, okay? Very much. Virginia Tech. We have an engineer available. Is there anything? Okay, I've got to see, I've got to see. Most have a board. We'll pass over to Virginia Tech and understand that she's turned herself into Jamie Harold. Versus Jamie Harold, 23 CR 0041. Are you Jamie Harold?
Yes, sir.
Born in 1977.
Yes, sir.
Last four digits of social security number 3525.
Yes, sir.
What does the Commonwealth have in this country? You gotta move over. But once you get on the inside.
I really don't remember. Mr. Pennington, I have any discussion about this case.
This was one, Your Honor, we were awaiting labs that we actually just received.
I think the lab has been supplied now. So I'd ask it be set for the 27th and next motion. We furnish the lab report on October 5th.
Negotiated Asian Day on October the 7th, and the next court date is November the 7th. That's got your money. Okay. Tyler Hall. Tyler Hall. Commonwealth Authority versus Tyler Holland, CR 0050, or Tyler Holland.
Yes, sir.
Where are you born in 1996? Last four digits, social security number 0898.
No, sir. 0690.
0698. Okay. Retrial conference was a time.
This is the same situation. We received the lab on October the 10th. Our furnace is Mr. Clinton, so I asked it to be the 27th for the next
Can
motion.
you be here for negotiation day, sir, on October 22nd, next school dates, November 2nd, conditions regarding open plants.
You said it's 22nd or 27th.
27. Okay. Is that at 9 a.m. on all?
No, it's at 1 o'clock.
1 o'clock. 1 o'clock on the 27th, 9 a.m.
I think that's right.
You want to write those down?
Oh, it's 9, Your Honor, I'm sorry.
9. Yeah. Cody Key. Hollow versus Cody Key, 23 CR 0014. Are you Cody Key?
Yes, sir.
Born in 1984.
Yes, sir.
Last four years of social security number 2180. Correct. What's the kind of evidence?
I'd asked the trial be continued in this case because I had 2 witnesses unavailable. I'd like to set it for the 27th at 9. If we can't reach a resolution, I'd get another trial date.
Negotiation on the 27th. Next court date on the 2nd. Let's look at the calendar. There hadn't been any inclination for any kind of settlement at this juncture, so we go ahead and get us a trial date. Hope it turns around. How much time are you gonna need in front to get your witnesses?
Probably 30, 45 days, 30 days.
What about November the 8th?
I've got tons of stuff that day, Your Honor.
Your Honor, we've got 6 trials. Now in November the 20th.
That's not a good day for either one of them.
No, I'd like to do something after December, and I think the problem I've got,
Picking up the thing here. Okay, let's go on down. Okay.
the Richardson case that Mr. Cross has, that we continue to furnish the documents the day before.
Okay, let's go down a little bit.
Bryce and Cross is when we leave going to Army on December 16th, so I do need to get that tried before December 16th.
Is it set?
No, it was continued, it's on the docket today,
Okay, well,
but it needs priority over this one, because I'll have an unavailable witness for years after December 16th. So if this one has to be pushed out, we'll do that. We've not had any complaints on the bond.
This time of year, things get a little dicey, you know. Holidays. You said November 8th was too soon. How about December the 4th?
That's
That would be good for me, Your Honor.
The same conditions bond.
Your Honor, he's been on the ankle monitor now 260 days of the Commonwealth had shops. Well, not since we.
We'll tender an agreed order.
okay. That'd be all
All
right.
right, if we can get off the ankle monitor, he still stays on the same curfew.
I got you. Thank you. Your Honor, cautionary, this one may take 2 days because of the complications of the 404B ruling and all of those.
Probably we could one day, but I won't schedule anything on the next
We
day.
may not.
Well, I may rain that day. Justin Lynch. Justin Lynch, Commonwealth versus Justin Lynch, 22 CR 004. Justin Lynch.
Yes, sir.
You born in 1975.
Yes, sir.
That's 4 digits, it's a social security number 75, 97.
Yes, sir.
Dale, 3 trial conference.
Your Honor, it's a motion, initially it's the wrong motion was filed, it's a motion for supervision. He was administratively discharged from drug court due to medical reasons. I'm just asking to be placed on supervision and probation for the remainder of these time. Probably about 4.5 years.
Well, do you have any recommendation for being interviewed by conditions or anything to see if any?
Not unless he has a violation, because he has.
I haven't had a violation.
So
I did home incarceration.
Sorry, you're doing pretty good right now. Okay. Silence, go. Everything step over until your turn. Okay, I'll just, we can send you the order outside. Okay. Rodney Mintz. Yes. How about the title of this? Commonwealth versus Rodney Mintz, 22 CR 007. Are you Rodney Mintz?
Yes, sir.
Born in 1970.
Yes, sir.
Last 4 digits, social security number 4824.
Yes, sir.
We're here on 22 CR 007. What's the Commonwealth have to say about that?
Now, this is Commonwealth's motion to revoke probation.
Y'all need to step back and bring them there, because I have a discussion at Ken Mike's, okay? What'd you say?
This is the Commonwealth's motion.
Wait a second. I said step back in the room if you're gonna have a conversation. Probation parole officer, go back there with you, if you need to, I don't know. What'd you say in this case?
This is the Commonwealth's motion to revoke probation. Mr. Manis owes approximately $21,000 restitution. He was supposed to be paying about $150 a month. And he, 2023, he's paid $207, and 2022, he paid $530, and he's $2,020 behind.
I've got a new job, Your Honor. The last job I had, my boss had.
You know, I'm sorry you got problems in your life, greatest worst jobs. But this is, the dog ate my homework time. Okay. What do you want him to do?
I want him to have a lump sum paid, call it next motion day and have a job, because he's had 2 years to pay this.
I've chosen God.
Don't say anything else. You can be back here on November 2nd and be up to date and show that I want a job that you can have a wage assignment on. Not too well. Don't pull anything out. It's not time for you to do anything. So just be glad you're walking out of here today.
Okay.
Life is good. Okay. You have the payment made to do a wage assignment because you haven't been doing too well as far as volunteer paid. So we'll get you on the right track. Talk to your lawyer. Come back up here on that day. If you paid it in full, as far as the catching up, you don't have to be here that day. But I don't, unless they become the first approval. Well, the proof will have to furnish your attorney to provide it to the Commonwealth and they'll do a agreed order. It's formalized. If not, come and bring your toothbrush. Okay? Robert Myers.
Here's
21 CR 0081.
handling matters if you want.
Are you Robert Myers Jr.?
Yes, sir.
Born in 1967.
Yes, sir.
Last 4 digits, social security number 3705.
Yes, sir.
Okay, we have it down for sentencing. And also have a motion to withdraw. What's the Commonwealth have to say?
Judge,
Just sentencing?
Judge, it's actually, Mr. Myers was referred to specialty court. He was disqualified, or not eligible. Thus Commonwealth withdrew their offer.
I would ask if he's not accepted in the drug court and the court still wants to accept the plea, that there needs to be a substance abuse counsel put in along with anger
Well, it
management.
just had sentencing here.
Yeah, so I don't know that,
Well,
I thought
is
the
that
court rejected the plea.
I'm confused.
We had an initial plea for 5 years, so both cases with special. Well, he doesn't qualify because of his criminal history. In the meantime, I got to looking into these domestic violence, and it's not good. Because what he does is he gets intoxicated and harasses these women, and they'll put him on probation and convert him down to district court. It's got 3 or 4 of those cases. So something's got to give. So that's the reason I think you need some type of substance abuse counseling and anger management counseling, or he's going to go back to penitentiary.
Okay, what I'm gonna do, let's schedule him to come to a negotiation with you on October 27th. Maybe y'all can make some suggestions as to what it's needed. You can have one of your clinicians interviewing or that sort of thing, to see what sort of, if it's a person that's amenable.
I have a proposed plea that I can tender at that time.
Okay, well, once you give it to them beforehand and they can review it, you come back here on the 27th and we'll have you on November 2nd, okay?
Yes, Your Honor. Yes.
Terry Phillips Jr. Terry Phillips Jr. Commonwealth versus Terry Phillips Jr., 21 CR 006. Are you Terry Phillips Jr.? Yes. Born in 1986, sir. Last 4 digits of social security are 9701.
Yes.
The rear for it says review, what's the Commonwealth have to say?
Your Honor, my understanding is Mr. Phillips has been paying per month, it's $1,000, $2,000.
$1,000.
$1,000 a month.
Very diligent on that.
I also got a letter from his counsel in Tennessee, furnished to Mr. Cross. He's supposed to have a trial in November about the Tennessee lawsuit. So I'd ask that it be reviewed in December or January so we can see what happens.
That's, our rule day in December is fairly early. What, you know what our January rule day is? We set those out. January the 11th, be back here on January the 11th.
Mr. Cross, inform me what happens in Tennessee.
I will certainly do that.
Okay. Christopher Pierce. Christopher Pierce. Commonwealth versus Christopher Pierce. 23 CR 0038. Are you Christopher Pierce? Are you Christopher Pierce?
Yes, sir.
You born in 1981?
Yes.
Last 4 digits of social security number 9875.
Yeah.
We're here for a pre-trial conference. What did y'all move your left a little bit? Mr. Stockton, what do you get?
We have a proposed plea here.
What kind of plea?
Version.
Sir, a motion has been given that says you wish to include that. Is that correct?
Yes.
We're currently under the influence of drugs or alcohol. Is this plea free and voluntarily given?
Yes.
Free and voluntarily given?
Yes.
Are you the same person named in indictment number 23 CR 0038?
Yes.
Is your judgment impaired today in any way?
No.
Can you discuss this matter with your attorney or are you satisfied with his advice?
Yes.
If you need it, it's Commonwealth has against you before informed about your case.
Yes.
You do not have to enter into a plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm going to go through the rights and at the end, I ask you. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury. Right to be represented by counsel to jury trial. Right to confirm the causes of my witness. I'll testify against you. Right to produce evidence. Right to know witnesses in favor. Right to bill this matter to higher court. Right to call a Commonwealth. Give up those rights. You understand that?
Yes.
I may consider Commonwealth's recommendation. I may find it to subject to the law. I do not accept the recommendation. Punishment. I understand the proposed plea has to do with a pre-trial version. So So I'm gonna ask about your qualifications. Have you previously been converted in the last 5 years?
No,
Have any felonies in the past 10 years?
no,
Are you currently on probation?
no,
You understand if you fully complete the first person, the charge will be dismissed for trial for any that your record is expunged. You understand that?
yes,
You understand if you do not fully complete the first one, you will be brought back before this court, the court will schedule a sentencing hearing. You understand that? What's the Commonwealth's recommendation on to your left?
Your Honor, Mr. Pierce would plead guilty to possession of a controlled substance, first degree, 3 years, pretrial verdict. It says 3 years, it should have been 5. Let's say the defendant shall be referred to the Social Service Commission, following all recommendations of the clinician. I've spoken with the county attorney in Wayne County, that no insurance will be dismissed down here. He has a no insurance second. This involved a traffic violation that started in Wayne County and ended in Clinton County. And that's when they found the lead. So he's gonna have to face those charges up there. He'll receive credit for time served, obtain and maintain gainful employment, and all evidence in this case will be destroyed.
Sir, is that your understanding of the Commonwealth's recommendation?
Yes.
Is anyone offered you anything to do this or been threatened anyway?
No.
Because your argument to get the act starts in the indictment.
Yes.
We go on your own free will.
Yes.
Constitutional rights that explain to us in 2 years out, go ahead and enter this plea now before fiction comes.
Yes. Yes.
Is that your signature?
Yes, sir.
I'll accept please sign the version where you need to meet the probation parole to give certain information. Jeffrey Reagan. Jeffrey Reagan. Revocation, issue of bench warrant. John Richardson. John Richardson. Moore versus John Richardson, 23 CR 0024. John Richardson,
Yes, sir.
born in 2003.
Yes, sir.
Last 4 digits, your social security number 1533.
Yes, sir.
What's the comment of young people left here?
Your Honor, the trial was continued. This last time, on the day of the trial, still had the sheriff's department. They were kind enough to bring Mr. Krause down. I interviewed him at length about this case. He's the juvenile that I couldn't charge in circuit court.
Yeah.
And so, and I furnished that statement to Mr. Krause. And I found out from the juvenile, he's in some type of program at Fort Knox, where he's basically in the Army now. And my understanding is he'll go to active duty on December the 16th. He'll be shipped out. So I need a trial date before then, or his testimony needs to be taken.
Your Honor, he's off. Mr. Richardson's going to need an attorney. We were prepared to go ahead and try the case despite some challenges, but when it was continued, I find it necessary to move to withdrawal for multiple reasons. Just a conflict between counsel and client that merits withdrawal.
Do you agree that you have a conflict with your attorney?
Yes, sir.
You have another attorney in mind?
Your Honor, in my opinion, you'll qualify for the public advocate.
You fill an affidavit. Who's got that affidavit? So go over that room there and fill out the affidavit. We'll come back to Mr. Richardson. Johnny Stevens. Versus Johnny Stevens, 18 CR 0059. Are you Johnny Stevens?
Yes.
You were born in 1977.
Yes.
What are the last 4 numbers of your social security?
3940.
What?
3940.
There's a probation revocation.
That's correct. This is our secretary.
Mr. Stockton, you get behind.
Yes, Your Honor.
Mr. Richardson, Mr. Stevens is also supposed to pay restitution. When I filed this motion, he had paid $138.50 this year, and he's supposed to be paying $75 a month, so he's about $600 behind. Paid about 20% of what he's supposed to pay.
What do you have to say?
Judge, this is my first time meeting Mr. Stevenson, but it's my understanding, Mr. Stevens, my apologies. It's my understanding that this morning he made a $25 payment.
How much is supposed to be paid a month?
75.
Look, man, are you disabled? You have any, you're not working any at all, doing anything? You draw an SSI or Social Security, what do you
Yes,
draw?
SSI on the 3rd of the month.
You what?
I draw a check on the 3rd of the month. I think SSI.
What is this restitution for?
Case sold, I have to look it up. He was charged with theft. Is a $3,000 theft from the Royal Inn Hotel.
And a $3,000 theft from the Royal Inn Hotel. Him and his wife were working out there, and evidently there's some money got distributed or displayed to make restitution on conversion. And he's just not paid, they're just not paying. And I agree, this is the thing, Mr. Shepherd representing. I agree with dismissing his wife for order him to pay this restitution. He's just not fulfilled his part. You know,
Is your wife drawing too? She working?
No.
Is she able to work?
Yes.
What's the deal?
We're just having a rough time right now. I mean,
Well, one of the reasons you have a rough time is because she's an able-bodied person and is not working. There are people hiring somebody every day. Now, I'll accept the fact that you've been adjudged to be disabled. I can't redo that. I have a lot of people come in front of me that say they're disabled, they're drawing. Who am I to question that? But I've got my doubts about whether it's something they can do. So once you told them,
I feel like I've been short.
we'll fix and take care of that. How much?
I want it paid up to $750 this by the next motion day. Him and his wife.
What's the total amount? So 3,000?
It was 3,000 to start with, and I think there's probably been a few $100 paid on the 138 this year, and a few $100 last year.
But I don't think that, I don't think that they come up with $750. But here's what I understand. I want you to have $250 paid each of the next 3 rulers. 250, 250, 250. Now, your wife was not indicted,
She wasn't that. I just missed the case.
not with prejudice. Will you see,
I'll check on
check,
that.
we'll check, see if it was, if it wasn't with prejudice on there, she can be indicted. We need to talk to her and two of you together, because one or both of you are gonna pay this. So by November 2nd, you're to have $250 paid on this, $250 more paid on it. And then by December 7th, $250. And then January 11th, $250. And then we'll get you back to your normal payments. Now, this $250 is not on top of your normal payments. It is the total payment you're to make for each month, okay? And then after that, we're gonna get back in rhythm. And between now and then, Mr. Stockton is gonna see if it was dismissed with prejudice, and if it wasn't, I think he's indicated the inclination that he might take her in front of the grand jury. Okay, you understand what I'm saying?
yes, sir.
Okay, thank you very much.
Thank you, Judge.
David Sullivan. David Sullivan. He's not here. There's an active warrant out.
We'll put him in CS.
Did you catch that, Mr.?
Yeah, we'll put him in CS.
Rachel York. This is the expungement docket. I hope there's no objection.
No.
Now we'll go back up here and take John Richardson. Find that Mr. Richardson is eligible.
Yeah, it's in my phone there.
Mr. Richardson, could you pass the test today? Why don't you be honest with me?
Yes, sir.
Okay, well, let's give you one to see, okay? Staggering back across the wall back there a little bit. Get somebody to take a test here. We'll go ahead and point for the camera. All right.
And Judge, I will note for the record, I represented the juvenile, so it may raise a conflict. I can check with conflict counsel. But the one issue that raises is that presents a problem for Mr. Stockson's timeline. So I just wanted to note the report.
I had this discussion with Mr. Pennington a while ago. I hate to tell anybody how to practice their case, but the case law is clear. He represented Mr. Cross in juvenile court. Mr. Cross's case is over with. He has a multi-team firm, and any person in his firm can handle this case without a conflict because they can build a firewall. There's a Supreme Court case where assistant Commonwealth attorney was hired from DVA, and that Commonwealth attorney was still able to try that capital case. So I don't see how there could be a conflict in this if somebody else in his firm handles this case.
Judge, I can check on that, but again, I don't know how that's going to fit into a December 16th.
Well, you have anybody else in your firm that does these cases? You had another gentleman down with you one time.
I do, Your Honor.
Is it just busy? Beautiful this time of year, guys.
It is. It's all about the foothill festival. Last time you see it.
You have his calendar, your associate's calendar.
I do.
Let's go ahead and just trial that. If you want to file a motion after that with some good grounds, why you can't do it, then we'll hear it. Okay. Why he can't do it. What I'm saying. This is a priority case for you, he says.
Well, yes, because after the
Well, I
16th.
understand why he says, let's look at November to give them enough time to prepare too.
Yes.
Okay. What date in November do you have?
27th through the 30th. I'm available. About it.
Judge, my partner will be out of state for the holiday.
29th Thanksgiving.
No, it's early this year. It's the 23rd.
There's no holiday then.
But I'm looking at this calendar item out 23rd through
Oh, okay, there is a holiday.
1st.
There's a holiday. When's he coming back? First.
8, 11, 12, 13. Third, he said first.
Yeah. When's your guy?
He's leaving the 16th, what he comes in
December?
of December. Hate to cut it too. That was one reason we told Keith, I was kind of want to push it out, because I was afraid this would come up.
Judge, we have a jury trial or Ryan has a jury trial in Fayette on December 4th. We have jury trial in Jefferson, December 6th. 2 days into the 7th.
What about November the 14th? We have one trial, we have 3 trials in a row there.
That thing moving on the 3rd, 13th, and South Jesse on the 15th. So we have one on the 14th.
I don't have anything about it.
Which did we contemplate going into the 14th on Thing Lou because of the district trials? Because I'm doing the Thing Lou trial on the 13th.
Also, on that, I was also told that the district court that day has 14 jury trials.
On the 13th. Well, let's just do it on the 13th. Do it here. That's not a district court trial problem in.
This report here.
No, for speedy trial.
No, on the third, what are you saying? What about 14?
No, the third issue on there.
Said something about.
That was.
That's the district
Wow.
court, but
Right, but we said, so we said, Lou, there, you just make a testimony in the lab.
If we continue to lose at this show, it's on the 13th. Then we would, we'd solve two problems.
Mr. Lewis on the floor.
Actually, Judge, that was the problem with the 14th, and the reason why we went to the 13th was because the lab examiner was only available the 13th.
Yeah, we have to continue to lose the later date, but he's not looking for a speedy trial. So we send him to jail for it.
Somebody in jail. Trial, I got to expert witness scheduled for that. You know,
under close to every
on 14.
So I was gonna say, Judge, if there's no way we can do the 13th, I don't know that we'll do Mr. Lou, the expert anyway.
Well, I remember saying that we were gonna schedule both of them that day, and that we would start in the afternoon.
At 11, as we said, that they have 14.
They won't try it, they never try again.
They make this have different regime there.
Actually, I think I have one, I have a trial scheduled in
They were
district
separately-
that day,
that's what we did.
at least one, it's mine.
Okay, well, we'll leave, you, what I wanna do then, we'll go ahead and change it to the 13th.
That's your issue.
Well,
We'll just do Mr. Richardson on the 13th. And we'll have another motion day in Herman.
well, let me tell you what, if we're doing this case, if those district court trials on the 13th, we could do the case here on the 14th.
No, we don't have a last person. That's our problem. On the blue.
I'm not talking about,
Oh, you want to do Mr. Richardson?
if you do Mr. Richardson here, that'd take care of that problem. And that way you can do your trial on the 13th.
Yeah.
And we'll need to get a great order probably to continue Mr. Lou as time comes up, in case they get all those district court cases, so we'll just leave it sit for that for a while, if that makes sense.
Yes, that's it. So,
In case they settle.
Yeah.
Yeah,
Mr. Richardson was possible.
that's what I thought. Mr. Richardson is positive for meth. Appears to be under the influence of the off the wall back there. What's the Commonwealth have to say about that?
I would ask that he be sanctioned, whatever the court deems appropriate.
You're in the custody of the jail. You need to search him before you handcuff him. Matter of fact, handcuff him out here, so that the case is in resistance. Okay. And then you pass somebody else over on the, is Virginia Catherine in process downstairs?
She's at the jail in McKinney, waiting on somebody to make her property.
Well, I guess we need to add her, we don't have a jail doc yet, add her to Clinton County Jail doc.
Yes, Your Honor. She was represented by DPA below, so.
I think we'll stick to that. Yeah, but I want to draw it up. Yeah, we need to get it
Okay,
brought up.
let's go off the record. Next thing we have to do that is 10 o'clock going to the Dare County Jail. The rest-
Your Honor, we've got Mr. Daly on for
Okay, let's go to Dare County first. Dare County, are you on there? Okay, if Wayne County, if you'll turn your camera off. Yeah, yes. Wayne County, you have your camera on? So it says Bobby Phillips / Benjamin Carson. Okay, it will be y'all next, you'll just turn your camera off just for a second. Okay. Okay, this is the Dare County Jail. Okay, at Dare County Detention Center, Jameson Mallon. Are you Jameson Mallon? Dare County, we got somebody on the telephone here. Look like on the telephone.
They have to their audio up there.
Hello, sir.
Yes, are you Jameson Mallon?
I am not, Your Honor. Jameson Malum is currently still talking to his lawyer at this particular second. He is currently on the phone with Mr. Pennington, I think is his lawyer, before he talks with you. I don't know about what in particular, but if you would like, I can definitely go get him right now. Right. He's coming right now. He's actually right here, sir. Hello.
We don't need you on the phone, man. You can hang the phone up.
I'll hang the phone up.
And sit down there so we can see your face. Here. Are you Jameson Mallon?
Yes, sir.
Born in 2003? You born in 2003?
Yes, sir.
That's 4 digits, social security, 6044.
Where the kids play?
6011.
6011, is that what you said?
Yes, sir.
Okay. Person revocation. What's the Commonwealth have to say?
Okay.
Your Honor, Mr. Miles on pretrial diversion for possession of controlled substance, 3 years, receiving stolen property, a firearm, 5 years. He was placed into the specialty court program. He was terminated on September 11th of 2023. He had the following violations: positive for marijuana on May 15th, 23, positive for marijuana June 8th. Then he was arrested for trafficking in a synthetic drug in Cumberland County, which he has been indicted on 8/9/23.
Yes, Your Honor.
Mr. Biden wants to stipulate to diversion and revocation. Well, I'll order I'll vote for pretrial diversion, set a sentencing on November 2nd. I'll order pre-sentence investigation report. Probation pro will be up to talk to you as will your attorney to talk about the cases you have in the several counties so they can get this rolled up for you, okay?
Yes, sir.
Okay, we don't have anything else in Adair County, I don't believe so. Adair County, thank you for your cooperation. You're excused.
Thank you, Your Honor.
Well, let's next take up Western Correctional Complex. Western Kentucky Correctional Complex. With Bobby Phillips and Benjamin Clayton, okay? I'll turn your camera on. There you guys are. Okay, Commonwealth Kentucky versus Benjamin Clayton. Mr. Clayton, we kind of wave your hand.
Do what, sir?
Kind of wave your hand, Mr. Clayton, so we can differentiate you on the record from Bobby Phillips. Okay, Bobby Phillips, you kind of wave your hand. So we're going to call Mr. Clayton's case first, which is 22 CR 0047. Mr. Clay was born in 1986, is that correct?
Yes, sir.
And the last 4 digits are 2415. What's the Commonwealth have to say about this? You come forward. This is a pretrial conference, a motion for reciprocal discovery.
Which case are we on? Your Honor?
Well,
Phillips?
Benjamin Clayton.
Benjamin Claywell. On Mr. Claywell, I got a text from Mr. Sheffett and Ms. Costello that they wanted to meet
Both
with,
online.
that they wanted to meet with me on this case prior to mediation. So that's where we are on that case. And I told them, I think they said September 27th.
Well, they're both here. What do you have to say, Mr. Shepard?
Yeah, and it was Tuesday, Jesse, this coming Tuesday, and then we've already reached out to Judge Patton.
Turn your camera back on.
Well, what happened there?
There you go. That's off. That's off.
Okay. We've already reached out to Judge Patton about the possibility of mediation, but we thought it would be to get started so we know where we're at heading into mediation to meet with Mr. Stockton. I do think this is a case that can be resolved.
It will also put on the calendar to November the 2nd. That'll give you all time to get some resolution to it. And on November 2nd, we'll come for we'll come to set a trial date on that date if there's no resolution. And that way I won't do a negotiation date since y'all are trying to get a mediation done. Okay. I'll just trust y'all to do that. You understand that, Mr. Claywell? We're going to try to get with a mediator, see if they can mediate your case.
And Ben will be getting with you too, in the midst of all this. Okay.
Okay.
We'll go to Bobby Phillips, Mr. Bobby Phillips, which is 21 CR 00110 for a pretrial conference. Who represents Mr. Phillips? Can you move over, Mr. Stockton?
Yes.
What do we have on Mr. Phillips' case?
Judge, this is the first time that I have seen Mr. Phillips.
Yeah, Mr. Sheffett was representing him. I didn't know if he kept that case or not because we hadn't done anything on it in a while. It was set for mediation. We mediated the case. We were unsuccessful.
What is the trial? What is it about?
It's an alleged attempted murder case where Mr. Phillips shot at Michael Winningham. And I was intending on trying to get a trial date today. I didn't realize Mr. Pennington was on the case. But I would ask that we have another month so he can review the case. And also I need to reach out to Mr. Winningham. My understanding is he's had a stroke and I'm going to have to find him.
Okay, well, what we'll do then, Mr. Phillips, it seems like your case might have dropped through the cracks here on a little bit. So what I'm going to do is set a negotiation date for October the 27th and a trial date on November 2nd. A pre-trial date on November 2nd. And on that date, we'll either set a trial date or take a plea, and you'll go to the front of the line, Mr. Phillips, since there's kind of been a change of attorneys here, okay? So we'll make sure that you hadn't lost any time because of change of attorney.
Mr. Phillips, I'll be in touch with you soon.
Thank you.
Okay, thank y'all. Thank Western Kentucky Correctional Complex. We don't have anybody else there, and y'all can be excused. Thank you very much. Okay, let's go to the Russell County Detention Center. Let's go ahead and turn them off. Clinton County, if you turn your camera off for a minute. The Russell County Detention Center, Commonwealth versus Alfred Silva. 23 CR 0012, Commonwealth versus Alfred Silva. Are you Alfred Silva?
Yes, sir, I am.
Born in 1962.
Yes, sir.
Last four digits, social security number 3706.
Yes, sir.
Okay, let's see what we
Your Honor,
have.
we're really close to an agreement. We need to, if we set the 27th and the 2nd, I believe we enter a plea.
Okay, Mr. Silva, I don't know whether you can hear that. They said the negotiations are going very well. They're going to get together with you on the 27th. And if they can reach an agreement, then you'll be back here to tell the court what your agreement is, either enter plea or set you a speedy trial date, okay?
Yes, sir. Thank you very much, sir.
I'll be over either today or tomorrow to see you.
Yes, sir. Thank you.
Okay, Russell County, thank you for your cooperation. You'll be excused. Let's go to Wayne County.
Thank you, Your Honor.
Jesse Pittman,
Yes, sir.
Commonwealth versus Jesse Pittman, 23 CR 003 yard Jesse Pittman,
Yes, sir.
1986.
Yes, sir.
Last four digits of social security number 5676.
Yes, sir.
Okay, we're here for pre-trial conference. What do we have? Mr. Conference, can you come up?
Your Honor, we need, Mr. Payne not discuss this case. We need an interim to have her evaluated.
No, this is Pittman.
Oh, Pittman, sorry, I thought it was on Miss Owen.
Yes.
Go ahead.
Judge, we're ready to set trial.
What's the charge?
Kidnapping.
Mr. Stockton, how many day trial do you think this will be?
I would think one. I need to talk to Miss Rich, so I'm when I'll be ready. I've had no contact with the victim, I want to see if she has. Can you all look and see if Kenzie Pruitt is on probation?
She is,
You know where she's at?
she is. Last time she was.
That's my problem as far as the trial date. Locate.
Well, let's not talk about where she was in prison. So,
So I would ask for a little time on this so I can locate the victim, meet with her.
let's schedule this.
This is the first pre-trial.
Trial of the 27th. Negotiation day on the 27th and a pre-trial on the. And this is a kidnapping case.
The facts as alleged is she went to Mr. Pittman's residence. He wouldn't let her leave for 2 or 3 days. She was assaulted, which was probably a misdemeanor assault. And she got away to Monticello, and then she reported this. And then the police in Monticello referred it back down to here. So that's the allegations.
My client, his father went to pick her up at rehab. That part was left out.
No, I didn't mean to. I just can't remember everything.
Yeah, that's
I-
fine. Yeah,
Yeah.
she's absconded from rehab.
Yeah, that's
At the beginning.
correct. So I guess they aided and better from the absconding from rehab and picked her up. And then they would, according to her, they wouldn't let her, Mr. Pittman wouldn't let her leave.
Judge, he's a state inmate and he's already been swapped over for I want to say a 12-month deferment.
Okay, well, then Mr. Pittman, I was worried about your bond, but since that's not an issue, since you're already state prisoner, I was going to try to get you out since it's going to be.
Yeah, Your Honor. I mean, this has already got me revoked, my parole revoked, and I was doing really well. And it's Alex. She just made up lies to try to go to rehab, to get back in rehab. And I mean, I've lost my grandmother since I've been sitting here. My last month with my grandmother. This has been a really bad experience for me. And I tried nothing besides to help the girl. And she was drunk was the whole problem.
Okay, I understand. I was going to try to do something for you. There's nothing I can do for you right now.
Okay.
I ask you not to put any more facts out there. I just say that my eyes on this case.
Thank you, sir. I really appreciate it. I mean, you can, it's.
Wait. Don't, your lawyer, I don't want you to say anything else, but you might.
Okay, thank you. I won't.
There's gonna be a negotiation date on this on October the 27th. And we'll have another pre-trial on November 2nd and see if there could be some resolution to this part of it, okay?
All right, thank you, sir.
This might be one that we need to have transported to. So,
Maybe we should have her transported.
yeah, okay. Thank you very much, Mr. President.
Thank you, sir.
Janet Owen.
Yeah, here she is.
Janet Owen. Harlow versus Janet Owenby. 23 CR 0035. Are you Janet Owenby? Are you Janet Owenby?
Yes,
Okay. You were born in 1962.
yes,
Last four digits of social security number 0936. Is that right? Child conference. What's the study charge?
It's
Assault of a police officer, Your Honor. This is one that we're going to need to have Ms. Owen be assessed for competency.
Yes, and we'll enter an agreed order so she can do that outpatient, and it's not out, we're like video, or so they go quicker instead of take her case in PC. We just need to get that taken care of.
Give me a little background on the level of assault.
It was with a skillet. Chief Mark Bell went over to answer a complaint. He's known Miss Owenby for a long time. He really liked Miss Owenby. And he said she was out of her mind and she hit him in the head with a skillet. So,
I didn't hear you.
but Mr. Bell doesn't want to send her to prison. He wants her to get help. It's Chief
Okay.
Bell.
Ms. Owenby, what we're gonna do is sign an order where you be evaluated. Okay, that somebody in case of PC will come down and evaluate you. This will be in your interest. Your attorney will be over to explain the details of who you're gonna come see her. She's in Wayne.
Today or tomorrow, Janet.
Janet, he'll be over there today and tomorrow, explain to you what's going on here and try to get you some help with you, okay? You understand what I'm saying? Your attorney's gonna be over there. I'm scheduling for September 27th. And Mr. Stockton,
Yeah.
what we need to do is, once we do this, we need to do some sort of assessment on where placement should be tilted.
I understand.
You understand what I'm saying?
Well, I know she has a sister in North Carolina, but I don't know
Yeah,
if she'd be willing
that
to
sounds
keep
like a
her.
good place.
Yeah.
Okay, they'll be over to see you. We reschedule you here. Your attorney will be over there today and tomorrow, Janet. You understand that?
Yes.
Okay, thank you very much. Wayne County, I don't think we have anything else with you. I'll thank you for your cooperation, okay? Okay, let's go to the Clinton County Jail docket. Okay, they're not on it in 13 minutes, so let's go ahead and, Virginia Catherine, you want to come around? Commonwealth versus Virginia Catherine. Withdraw the warrant. If I did issue, I probably didn't, okay, because she was downstairs all the time. Commonwealth Kentucky versus Virginia Catherine, 23 CR 0045. Are you Virginia Catherine?
Yes, sir.
Were you born in 1985?
Yes, sir.
Last four digits, social security number 5109,
5809.
5809. Please make note for the record, 5809. You have, you have a right to remain silent. You have an attorney.
Yes, sir.
Did this go through the district court? With the public advocacy represent you there? You have to say something. This is
Yes.
sound activated. Did the public advocacy represent you in district court?
Yes.
You have to speak up.
Yes.
Okay, well, I'm gonna continue that point. The grand jury have counsel come out. I continued the appointment of public advocacy to Ms. Catherine, who represented her in district court. The grand jury, Clinton County, has returned an indictment charging him with theft by lawful taking a disposition of a firearm. I don't want you to say whether you did it or not, anything, but you understand what the charge is. Counsel, you acknowledge the identity of Ms. Catherine, you see it out, no formal reading or interview, not guilty, preserve all pre-trial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order. Ms. Catherine says, Commonwealth should give your attorney information they have help. You can pay your defense. I will schedule a negotiation day on October the 27th and the next court day on November 2nd, October 27th, November 2nd. Both of them will be here at 9 a.m. Their conditions of your bond. You paid your bond, you can be on your way to rejoicing. Yeah, but comply with the terms of that bond. Attorney will give you a number and he'll contact you to help prepare the case, okay? And that'll be it. We'll go off record until 10:30 when we'll start the jail.
Hello, this is your interpreter. I'm sorry for the interruption, but could you all confirm for me that you actually need an interpreter this morning?
Yes. Yes, we do, but it won't start until 10:30. We'll call your case first.
All right, Your Honor, thank you so much.
We're on the record. Is this Mr. David Commonwealth versus Edward Daly? He's back here. Mr. Cross represents him. Mr. Cross, you want to bring Mr. Daly out?
You have a seat right there. Yes, sir.
Or is Mr. Shaw?
Okay, thank you.
Okay, we're calling Commonwealth versus Edward Daly, 22 CR 0013. Is Mr. Daly present in the courtroom? Are you Mr. Edward Daly?
I am Mr. Daly, Your Honor.
Were you born in 1951?
Yes, sir.
And last four digits of your social security number are 2842?
Yes, sir.
Okay, we're here for a conference. Who wishes to call a witness?
I do, Your Honor.
Commonwealth calls a witness. Who are you calling?
Dr. Maggie Green.
Larry, can we get him the earpieces?
Yeah, I don't care who you
Dr. Megan Green. Dr. Green, would you raise your right hand, please? Would you swear the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
We're getting earphones for the defendant, so we can hear.
I can say this all.
But let's not talk over there, okay? All right.
State your name for the record. Dr. Megan L. Green, PsyD.
And what is your occupation?
I'm a forensic psychologist in private practice, but I'm a contract evaluator for KCPC.
You said you were a psychologist?
Yes.
You're gonna have to speak directly into the microphone. Speak a little louder, please.
Are you licensed to practice as a psychologist in the Commonwealth of Kentucky?
Yes.
And when did you receive your license?
2010.
You need to speak up this way, or she can see your face.
Oh, okay. Please give the court a brief description of your education and training.
I have a doctorate in clinical psychology, postdoctoral training in forensic psychology. Excuse me. I've been in forensic practice in Kentucky since 2010 and in West Virginia since 2017.
And where are you currently employed?
I'm in private practice.
All right, okay. And have you previously been ordered by the court to examine the defendant in this case?
Yes, ma'am.
And to determine whether or not he's competent to stand trial?
Yes, ma'am.
And would you briefly describe the procedures or the process used to examine the defendant?
Yes. In terms of the general procedure, and this is really true for any defendant, there is a clinical interview to obtain the person's self-reported background history with emphasis on any kind of mental health history they may have had. We also do an IQ test to assess for any potential intellectual deficits. Also, if there is an indication of malingered psychiatric symptoms, we test for that. In Mr. Daly's case, there was not, so that was not administered. And then in all cases, there is a competency-specific test, and that is the evaluation of competency to stand trial revised, and that assesses the defendant's competency-specific skills.
And when did you evaluate Mr. Daly?
The evaluation actually took place on August 31st, 2023, and the report of the evaluation was submitted on September 8th, 2023.
Where did the evaluation take place at?
Via video conferencing. Mr. Daly was in custody at the Clinton County Jail.
And did you review any of his records prior to evaluating him?
In terms of the records that I had available, I had the court order, I had some discovery, and then there is also a pre-admission medical questionnaire completed by a combination of KCPC staff and jail personnel. And that questionnaire was dated July 21st, 2023.
Can you go over every test that you performed on Mr. Daly and also talk about the results of each test?
Yes. In terms of the IQ test, his intellectual functioning overall falls at 80. That is in the below average range. It's at the 9th percentile. He obtained a verbal standard score, which just refers to his verbal comprehension skills of 78. That falls in the below average range. On other tests, there are some that would call that the borderline range, depending on the test. That is at the 7th percentile. His nonverbal skills were slightly better developed. The score that he obtained in reference to those was also in the below average range, however, at 83. In terms of his competency specific skills, this particular test addresses the rational ability to consult with counsel, the capacity for factual understanding of proceedings, and the rational understanding of courtroom proceedings. In this test, he had a good factual understanding of courtroom proceedings. There were some inquiries where he didn't initially know the response to the question, but with education, he was able to demonstrate understanding. And in terms of his ability to participate rationally in his own defense, there were no deficits in that regard evident.
And based on your examination, were you able to reach an opinion as to whether or not the defendant is competent to stand trial?
Yes, ma'am.
And what is that opinion?
The opinion is that he does have the capacity to understand the nature and consequences of the proceedings against him, and that he also has the capacity to participate rationally in his own defense.
I have no other questions.
Mr. Cross.
Dr. Green, did you have any sort of diagnosis or provisional diagnosis regarding Mr. Daly's mental health or mental condition?
No, sir.
So, and is that something you did not delve into or?
Oh, no, we of course delve into it. He just didn't endorse any symptoms of that nature.
Okay. All right. That's all. Thank you.
Does anyone like to ask Dr. Green any additional questions? Dr. Green, that participate in that excuse.
Thank you, Your Honor.
Okay, what's Kamala have to say?
Your Honor, just based on the testimony from Dr. Green and based on her opinion, we believe that the defendant is competent to stand trial.
Mr. Ross.
Your Honor, I will say I was a little surprised at the level of the Weiss IQ scores. I've dealt with Mr. Daly before, helped him on his Social Security years ago. But based on the testimony, it would appear that the court must conclude he is competent to stand trial.
Let's schedule a negotiation day.
We might get it settled today. If y'all get hold of a victim. And Mr. Stockton was trying to reach Mr. Cravens today. We're trying to get this done if we can. If we can't, we'll do a negotiation day.
So,
Get hold of Jonathan Cravens.
I did. Your Honor, the victim in this case, I've explained to him, as much time as Mr. Daly is, if we enter a plea for time served, you know, if he gets 5 years, he's probably almost already public charge. It's a wanton endangerment. And what the victims say was happening, and this had happened before, that Mr. Daly gets down there and on his property, and he thinks that they're trying to take his property, and he starts shooting. He said they've never hit anybody, but it's been toward their direction. So, and I've explained their options on the case. Wanton endangerment, because nobody was struck. No property was struck, they weren't struck.
5 years.
That'd be the maximum he could get.
On each one of them.
That's correct.
So what's their position? They wouldn't go along. I mean,
Well, he doesn't need to get a firearm.
No.
Somebody can tell him that.
No, he's
Well,
not.
I would consider including us involved in felony conviction.
Right. I was going to offer 8 years on wanton endangerment, probated for 5, supervised, credit for time served. It's going to be my offer.
I would be willing to accept that.
and let me talk to Eugene while he's here. And I think that'll be agreeable, but I want him to understand.
Is it ever Eugene or?
Well, Eugene's where to go.
Okay, well, let's go down to the jail and start the rest of the dockets. Time yet? Yeah, I do. The jail needs somebody to call out to jail. Turn the radio on. We're gonna call Kelvin Rodriguez first, the interpreter's on. He's here. Commonwealth versus Kelvin Rodriguez.
Estado de Kentucky contra Kelvin Rodríguez.
Are you Kelvin Rodriguez?
¿Es usted Kelvin Rodríguez?
Sí.
Yes.
Yeah.
Sí.
Yes.
This is 23 CR 0047.
Este es el número del caso 23 CR 0047.
Were you born in 1989?
¿Usted nació en 1981?
Speak up loud, name again. Were you born in 1989?
¿Usted nació en el 1889?
Sí.
Yes.
Your social security number is 6235.
¿El número de su seguro social le acaba 6235?
6235.
6235.
You're here today for the purpose of arraignment.
Usted está acá hoy para que le lean la acusación.
Okay, do you have an attorney?
¿Usted tiene abogado?
Sí, pero no asistió.
You're going to have to speak up also.
Yes, but the attorney didn't come.
Did you pay the attorney?
¿Usted le pagó a su abogado?
No.
No.
They don't tend to come if you don't pay them.
Es que tienen tendencia a no venir si uno no les paga.
You have a job.
¿Usted tiene trabajo?
Sí.
Where
Yes. ¿Dónde trabaja usted?
En Tyson Food.
The interpreter could not hear, Your Honor. May I ask for a repetition?
Speak up.
Hable más fuerte.
Tyson Food.
Tyson's Food. Okay. Well, I'm gonna appoint the Office of Public Advocacy to represent you.
Yo les voy a asignar a los defensores de oficio para que lo representen a usted.
Counsel, do you speak Spanish?
Abogado, ¿usted habla español?
Okay, I'm gonna go ahead and arraign you, and then the Office of Public Advocacy will arrange a separate interpreter. So you can
Yo le
talk.
voy a leer la acusación formal y después los defensores de oficio ya arreglarán para que usted tenga intérprete por separado.
For purposes of arraignment. Do you have a case? Yeah, I guess I got that. The grand jury of Clinton County
El jurado indagatorio del condado de Clinton
has charged you with the following crimes.
lo acusa de los siguientes delitos.
Failure to eliminate registration plate.
No iluminar correctamente la placa, la matrícula del carro.
Fleeing or evading the police in first degree.
Darse la fuga o evadir a la policía, primer grado.
Resisting arrest.
Resistirse al arresto.
Operating with expired operator's license.
Hacer funcionar vehículo motor teniendo la licencia caducada.
Expired registration plates.
La placa de la matrícula caducada.
And failure to maintain insurance.
Y no mantener correctamente la aseguranza.
Counselor, do you acknowledge the identity of your client?
Abogado, ¿usted reconoce la identidad de este cliente suyo?
Yes. Receipt of the indictment.
Sí. ¿Reconoce haber recibido la acusación formal?
Waive formal reading and arraignment.
Y renuncia a la lectura formal y reconoce que le han leído.
Enter a plea of not guilty on behalf of your client.
¿Y usted hace una declaración de no culpable con respecto a su cliente?
Yes.
Sí.
I will schedule a pretrial negotiation on October the 27th.
Pondré en el calendario una audiencia de negociación previa al juicio, en este caso para el día 27 de octubre.
At 9 a.m.
Será a las 9 de la mañana.
In the next court appearance,
Esta será su siguiente cita en el tribunal.
November 2nd at 9 a.m.
Disculpe, la siguiente cita será el 2 de noviembre a las 9.
Both of those appearances are a condition of your bond.
Estas dos comparecencias usted se tiene que presentar como condición de su fianza.
Now, will this DPA need a separate order for another interpreter or we make those arrangements?
Ustedes necesitarán una orden por separado para intérprete o ya le va bien así como está.
Yeah, I would request that DPA submit an order to get an interpreter appointed as soon as possible. And then you get this gentleman's phone number or contact information. As soon as you get the interpreter, you'll call him.
Entonces yo dicto que ustedes tienen que hacer constar una petición para que les asigne intérprete de parte de los defensores de oficio. En cuantito tengan el de intérprete, ustedes con el número de teléfono, hágase usted con el número de teléfono, información de contacto con su cliente. En cuantito tengan intérprete, se ponga en contacto usted con él.
Okay, you understand?
Bien, ¿entendió?
Sí.
Okay.
Yes.
Okay, thank you very much.
Bien, muchas gracias.
I don't believe we have anybody else on the calendar here that needs an interpreter. So we'll be good, okay?
Right. Thank you, Your Honor. Thank you very much.
Yeah. Jeremy Burnell. Commonwealth versus Jeremy Burnell. Are you Jeremy Burnell? Somebody turn the microphone on. Clinton County Jail, you need to turn the microphone on. Okay. Are you Jeremy Burnell?
Yes, sir.
This is 23 CR 0046. Mr. Burnell, were you born in 1995?
Yes, sir.
4-digit social security number 0440.
Yes, sir.
You have the right to remain silent. It looks like you're represented by the Office of Public Advocacy. Your attorney is present here in the courtroom. If you see him on the screen there, you have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with reckless driving, wanton endangerment, the first degree, 2 counts, expired plates, failure to maintain insurance, criminal mischief in the first degree. Counselor, do you acknowledge the identity of your client received indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pre-trial motions?
Yes, Your Honor.
Mr. Burnell, I'm signing a reciprocal discovery order requires the Commonwealth to provide your attorney information to help you prepare for your case. We will schedule this for a negotiation day on October 27th at 9 a.m. and the next court date is November 2nd at 9 a.m. Both of them are conditions of bond. What's Mr. Burnell's bond?
10,000 cash.
10,000 cash or 2 times property.
Mr. Stockton,
Yes, Your Honor.
what's the deal with Mr. Burnwell? I guess I said his bond because he was, eluding the police and there was some wanton endangerment charges. And I want to take a look at it to see the level of danger. He didn't have any
Evidently, he was alleged to have been in an altercation at Reeves Trailer Park and then allegedly struck a vehicle from behind, causing a lot of damage. I don't see him fleeing or evading. It's 2 counts of wanton endangerment because there was 2 young men in the car.
Let me see.
And I'm not finding,
Who did that first? Who's charged up?
Reckless driving, wanton endangerment. No expired plates. There's main insurance. Criminal mischief.
yeah, the damage to the vehicle, about $2,600. He does, I've ran a criminal history even through NCIC. He doesn't have any criminal history of any
What's
consequence.
that? You said his bond could he make like a $25,000 clerk for sure?
Jeremy, have you got anybody that can do a surety bond for you?
I can get hold of somebody, yeah.
That just means that somebody in the state of Kentucky goes and convinces the clerk's office that they have, that can stand up for a $25,000 bond. And I'll change your bond to $25,000 clerk for surety with the conditions that where do you live, sir?
Here in Albany, 100 Reeves Lane, lot 14.
You shall stay at your premises there, and you should not leave your premises with the exception going to church, work, or the doctor, okay? And pretrial will monitor that. You don't need to get in contact with them. When you get somebody to make your bond, that'll be your conditions.
I want to just feed employed because they'll be restitution.
Are you employed anywhere?
Yes, sir. Tyson Foods for 7 years.
Okay.
I believe we ought to be able to do something where you work where you can get out and work.
Well, that's, you can leave the house to work, church, or doctor.
Yeah, let me know when you can make that.
And if you can't make the bond, your attorney will be to talk to, but one of the goals is get you out, get you back to work. Okay?
Thank you.
Okay.
Thank you so much.
Thanks, Judge. I'll be able to see you, Jeremy.
Judge, shall the condition of no contact with the alleged victim?
No contact with the alleged victim also. No contact with the alleged victims also.
Yes, sir.
Donald Kraft. Come on versus Donald Kraft. Are you Donald Kraft?
Yes, Your Honor.
1972.
Correct.
Last 4 digits, social security number 3460.
Correct.
And you're here on 22 CR 0074, a probation revocation. What does the Commonwealth have to present in this case? You step to your left, counsel.
Your Honor, Mr. Kraft has a 7.5-year sentence, robbery, second degree. He paid all the restitution in the case, which is $7,000. However, on May 16th, he got a positive for meth. He was scheduled clinician. They ordered him to go to CBI. He only went twice and didn't attend after May. He used meth again in July, and then he left the probation office on August the 4th before they could see him. He was supposed to return August 10th and didn't, so they've got use of meth, failure to report as directed, and failure to attend substance abuse treatment as directed.
Counsel.
Judge, Mr. Kraft has assured me if given the opportunity, he will go through treatment, whatever treatment is asked for or required. I think it's to note very important, he has satisfied his obligation for restitution. So Judge, we would just ask in lieu
Well,
of.
the problem with Mr. Kraft, and I don't want you to say anything.
I'm paying off court costs too.
Well,
Donald, don't say
I don't
anything.
want you to say anything right now. I want to talk to you for a second. Okay? I appreciate the fact that you paid the restitution, court costs, and that sort of thing. But you seem non-compliant. You won't probation and parole, and you won't keep under supervision. Now, do you have a job anywhere? You get out?
I'm gonna try to get a job as soon as I get out of here at McDonald's or Tyson's.
Where can you get a job?
Yeah, I think so. I'm pretty sure I can.
Are you, what?
Get out of Tyson's, I think. I put an application in.
Tyson.
Yes. Well,
Pardon me.
Mr. Stockton, is there any kind of, how long has he been in jail?
About 60 days,
How much?
60 days, 62 days.
62 days.
Okay.
Well, I'd like for a clinician to take a look at him.
Yeah, if he's going to get treatment, I think it needs to be.
Yeah, that's what I want, a clinician. So I'd like to order a clinician to take a look at you to see if they think that you need long-term. Or whether or not, you could be amenable to something less restrictive if you worked and us put you under close supervision. And I'm gonna tell you, Mr. Kraft, have you ever heard a thing of 1 foot in the grave and the other in a banana peel? Have you ever heard that?
Yeah, I've heard the same thing.
Well, you have got 1 foot in a penitentiary and 1 on the banana. And because you seem to have a history of working somewhat, I'm gonna try to work through it. So we'll come back, I'll accept an agreed order on him if there's a long-term treatment or if there's anything else that's acceptable, less than that. So they're gonna be coming out and clinicians gonna evaluate you. Now, you're gonna have to decide yourself, Mr. Kraft, whether your freedom is more important than the meth. I can't decide that for you, and I know it's not always easy. If it was easy, all those other people else would decide they don't want that meth anymore, and they'd be free too. So I'm not saying it's easy, but ultimately, that's your decision, okay? So somebody will be out to interview, and then a Commonwealth attorney and your attorney will consult, and I'm willing to give you a break and not send you straight to penitentiary with either long-term treatment in-house or something else and let you work one or the other. If you'll cooperate. And I have your word from here on out, you're gonna be compliant?
Yes, sir.
Okay, well, they'll be deceived.
Was he on the same?
Stay in custody till then. Yeah. Or until I receive it.
Well, I want to advise the court, it'll be a couple of weeks for the commission to get to it.
Well, it is what it is. Okay, they'll be down to see you pretty soon.
All right, thank you.
Your attorney will be there to explain it to you. Cody David. Commonwealth versus Cody Daly.
I'm saying.
Are you Cody Daly?
Yes.
You're here for sentencing. You have an opportunity to look at the pre-sentence investigation report done by probation and parole.
Cody, the paperwork we went over yesterday.
Yes.
Is it substantially correct, sir?
Yes, it is.
Okay, you were previously on a pretrial diversion, which was voided on September 14th, 2023. Is there any reason that this gentleman should not be sentenced today?
No, Your Honor.
Mr. Daly, I have reviewed the report here, and you're charged with burglary, third degree. Now, was it for 5 years, Mr. Stockton?
I'm sorry, Your Honor.
Was it for 5 years? It says pretrial diversion 5 years. So,
He was a period of 5 years, yes, sir.
well, I know, but what was the sentence?
What? This, the charge of robberies.
No, but what was the sentence? Was it 5? See, on here it says the verdict 5.
I'm on Donald Kraft, yeah. Yeah, it's 5 years.
Okay, so I'll go ahead and sentence you and make sure that you get time for credit for your time served also. Now, this is a 20% eligibility thing, is that correct, Counselor?
Yes, Your Honor.
Okay, so I'll sentence you to 5 years and make sure you get your full credit. Okay, thank you very much. Edward, we already did Edward Daly. Sydney Foster. Sydney Foster. Commonwealth versus Sydney Foster. 23 CR 0022 and 23 CR 0043. Are you Sydney Foster?
Yes, sir.
Born in 1972.
Yes, sir.
Last 4 digits you have in your social security number are 8738.
Yes, sir.
We're here on a pretrial conference. What does the Commonwealth have to say?
Your Honor, we were ready for
If you come
trial.
up here,
We were ready for trial, and then I went back and cleaned up the indictments on the thing, and we got it put off, so I'm ready to reset it for trial, but I asked if they said after the first of the year.
well, what is the charge?
Attempted murder. Wanton endangerment. Criminal mischief. PFO.
Sounds like it might take 2 days.
Yes, got several weeks.
Okay, let's look at January 22nd.
That's fine with me, Your Honor.
Looks good for me, Your Honor.
Let's talk about that just for a second. Apologize. Scott,
Yes.
you'll come up here. Mr. Foster, we're going to discuss the charges against you if you press and so you'll hear. You step back just a little bit so we get you full. That's good right there. I want you to be fully informed of what's going on here, so we're going to discuss it. Attorney, if you have any questions about what we talked about, we will come down and see you privately, okay?
Okay, there was 2 additional indictments on wanton endangerment. When Miss Beaver or Miss Thrasher prepared the indictment, she inadvertently added Mary Lou Delk and Johnny Duval, who were already on there for wanton endangerment. So I marked that out, so it wouldn't be duplicate. So there's two counts on wanton endangerment. And then on the PFO, she went and when she redid the PFO, she just included all charges on a new PFO first degree, which would be a superseding PFO. You got a supplemental wanton endangerment indictment, you got a superseding PFO indictment.
You understand that?
I do, Your Honor.
I think that, remember correctly though, she it was all the PFOs
That's right.
were reindicted.
That's correct.
So some of them are gonna have to be dismissed.
That's what I'm saying. This is a superseding PFO indictment. So all the old ones will be dismissed and this just be
So
the
if
new.
y'all agree, we're in order and submitted, dismissing the previous indictment and setting out that there is a superseding indictment.
Let's follow motions, so it'll be clear for the November motion.
Yeah, all the previous indictments, but just the ones that are covered by the superseding indictments. And that way, Mr. Foster, they'll have it cleaned up what the charge is. So when your attorney comes down, he can explain in detail. Okay?
And Judge, I know you, while we have Mr. Foster, I know you said it was a factual issue, but there's still some discrepancy on the PFO status, so. What is our discrepancy? The PFO 1 versus 2.
Well, that's
a charge issue.
Yeah, that's.
That'll be a matter of proof.
Yeah.
You know, if you've got anything before that it definitively states that out, you can file for a motion to reduce the charge with definitive proof.
I'm not going to pursue something I don't have proof of.
Yeah, that's right.
On the paper, it looks like it, but if it's paper expired, it's not a PFO first.
Okay. The issue is whether some of your PFO charges previously had expired, Mr. Foster, and your attorney's working on that diligently. He'll be talking to you, okay?
Thank you, Judge.
Thank you very much. Robert Harris.
He only accepts it.
Commonwealth versus Robert Harris. Are you Robert Harris?
Yes, Your Honor.
You born in 1969, Mr. Harris?
Yes, sir.
Last four digits of your social security number 3970.
Yes, sir.
Here on 23 CR 0031 today for a pretrial conference. What does the Commonwealth have to say if you get behind the podium?
Well, I think we have an agreement, Your Honor, if we could put it on for the, you want to do it today or you want to try to do it next month?
Probably next month, I'm out.
Because I didn't know.
Maybe do it from Monroe, put it on that docket.
Can we do it today?
We're trying to work.
If we can do it for Thursday and sentence in the second, it's not going to make any difference if we do it in Monroe. I mean, he'll still be sentenced on the second.
I've got time to serve.
Yeah, he'd be getting credit for time served, but I'm not contemplating releasing him prior to sentencing. That's our normal procedure, so.
Okay, what we'll do is we'll go ahead and they'll get the paperwork, sir, going, and we're going to allow you to enter the plea at the Monroe Circuit. Is that next week?
It is.
We'll let you enter, they'll get the paperwork to you. It's really not fair to you for you to sign the paperwork until you got a chance to go over it closely. See what I'm saying? Your attorney will be down there with you to go over it, and then we'll let you enter the plea, and that way we'll get you ready for sentencing, okay?
Okay, thank you, sir.
Thank you very much.
Okay, you have a good day.
Jeremy Kempton. Commonwealth versus Jeremy Kempton, 23 CR 0030. Are you Jeremy Kempton?
Yes, sir.
Here on 23 CR 0030. Were you born in 1981, Mr. Kempton?
Yes, sir.
Last four digits of social security number 2874.
Yes, sir.
We're here for a pretrial conference. What does the Commonwealth have to say? Ms. Gordon Anderson.
We have a felony plea, Your Honor.
Okay. I have been informed, Mr. Kempton, that you used to enter a motion that to do a guilty plea. Is that correct?
Yes, sir.
You're currently under the influence of drugs or alcohol.
No, sir.
Were you freely and voluntarily given?
Yeah.
Are you the
Yes,
same person named in this indictment here, 23 CR 0030?
yes,
Your judgment impaired today in any way?
no, sir.
You discussed this matter with your attorney and you feel like you're fully informed about the case.
Yes, sir.
Many times to review this matter and go over all of it. Are you satisfied with this advice?
Yes, sir.
Well, you have certain rights under the Kentucky and United States Constitution. I'm gonna go over those rights again, and then I'm gonna ask you to understand them. You have the right not to testify against yourself. No one can make you say that. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, and the right to appeal this matter to a higher court if you lose. You have the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of the charges against you. You understand that by entering the guilty plea today, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation that I may apply any range of sentence provided by law. I do not have to accept it. Prior to accepting any recommendation, I will wait the pre-sentence investigation report for probation control. In the event I do not accept Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea guilty and proceed to trial. Do you understand that?
Yes, sir.
Okay,
Yes.
Mr. Gordon Anderson, if you'll come up and get behind the podium and step to your left, counsel, so she can listen very carefully and see if this is what you're going to do.
Upon a plea of guilty to assault third degree, 2 counts, the defendant shall receive a sentence of 5 years on each count to run concurrently for a total of 5 years. Serve 151 days in jail with the balance probated for 5 years supervised. Defendant shall be administered his medication for substance abuse and mental health illness by inoculation. Proof shall be submitted to probation and parole each month. The defendant shall receive credit for time served, shall obtain gainful employment or do a minimum of 30 hours per week until gainful employment is obtained. Defendant agrees to have any and all evidence destroyed in a manner that is consistent with the laws of the Commonwealth and the holding agency.
Is that what you agree to, sir?
Yes, sir.
Are you pleading guilty because you didn't commit the acts charged in the indictment as amended?
Yes, sir.
Do some of your own free will?
Yes.
Knowing your constitutional rights and explain it, still your desire to give up those rights in this plea, is that correct?
Yes, sir.
Understand that after entering this plea, any future convictions could be enhanced as far as the range of penalty. Do you understand that?
Yes, sir.
Is that your signature on the document?
Yes, sir.
I accept the agreement or a pre-sentence investigation report and schedule a sentencing for you on November the 2nd.
Thank you, Judge.
Okay, thank you. Now, we need paperwork up here.
Yeah, I had to offer, I didn't have the motion, Judge.
I haven't found it. Lucas Pettinger. Lucas Pettinger. Are you Lucas Pettinger?
Yes, sir.
Born in 1987.
Yes, sir.
4 digit social security number 0933.
Yes, sir.
Here today for sentencing in 23 CR 0026 and 23 CR 0025. Have you had an opportunity to look at the pre-sentence investigation report and the probation control?
Yes, sir.
Is everything in there substantially correct, counsel?
Yes, Your Honor.
Is there any reason this gentleman should not be sentenced?
No, Your Honor.
On plea of guilty to indictment number 23 CR 0025 for the charge of strangulation, second degree and PFO, second defendant shall receive a sentence of 10 years. On plea of guilty indictment 23 CR 0026 for the charge of possession of controlled substance, first degree, methamphetamine, he shall receive a sentence of 3 years. The 10 years However, under that number 025, 3 years under 0026 shall run concurrent for a total of 10 years, serve 9 months in jail with balance probated for 5 years supervised. Is that what you agreed to?
Yes, sir.
Well, I entered the order. How much time does he have in?
Judge, the way we calculate it, he should have his time up toward the end of the year, but I don't have the exact date.
What are the court costs? $155. You pay that at $30 a month, starting 30 days after you get out of jail. That'll give you some time to catch up financially. And your attorney will review the days, make sure you get credit for all your time served, okay?
Yes, sir.
Thank you very much. Michael Ritchie. Commonwealth versus Michael Ritchie, 22-0015. Are you Michael Ritchie?
Yes.
You born in 1973? You born in 1973, sir?
Yes.
Last 4 digits of your social security number 4878.
Yes.
We're here on a trial diversion revocation. Will you step to the left, Mr. Stockton? Will you?
Your Honor, this is a case of wanton endangerment, first degree. The underlying charge was Mr. Ritchie had a gun out on a domestic with Milena Ritchie, and he pled guilty to 5 years. Evidently, after that, they continued to reside together. Then on July the 17th, Ms. Milena Ritchie took out additional charges. I can read those to you. Says that in March of this year, the defendant again became violent, abusive, and controlling, allowing her only to go to her doctor's appointments and dialysis treatment. The defendant would not allow her family to visit, allow her to have phone contact with anyone at all times, would even tie her wrist, so she could not leave. The fine was admitted from dialysis treatment center, Lake Cumberland Regional Hospital, where she was able to report her situation, who she was staying with. And so as a result, he got criminal charges from that. Now, the story doesn't end there. Ms. Ritchie tells our office that she had an infection from the dialysis and suffered a stroke and now cannot remember any of this. So I can't put her on, I can put her on as a witness, put her under oath, but that's going to be her testimony.
Like I said, I did suffer from a stroke. And I don't remember any of that. And as far as the strangulation, none of that I remember. Therefore, that is hearsay. I did not write the statement. I did not. Yeah, you probably have my signature, but I did not. I did not make that statement that was on the paper.
So you're saying none of this happened?
No, I don't remember anything.
Where were you in the hospital at?
I was in Lake Cumberland from June the 24th to the 29th, and then they flew me to Lexington.
Who was your doctor?
The kidney doctor is Dr. Helton.
Who was your attending physician when you were in the hospital?
Honestly, I have no clue. I vaguely remember that. And then when they flew me to Lexington, I don't remember any of it.
Well, if Mr. Ritchie is not revoked, my recommendation, of course, would be to change the conditions of supervision and so that Mr. Ritchie could not have any contact with Ms. Ritchie, because one of two things happened. Either she swore out an incorrect statement under oath, falsely charged him, or these things occurred, and in either case, he shouldn't be around.
Judge, it's not mutually exclusive that one of those two things happened. But the narrative, as Mr. Stockton read, it contemplates not being able to see family members. That reads like a third person more than it does a first person.
Yeah, I mean, he's not allowed to make.
Go
ahead.
No, you go ahead.
But no, I don't get where anybody says that I can't have contact. Everybody chose not to have contact with me.
Yeah. Judge, from the standpoint of no contact.
That statement is evidently it was wrote by my daughter.
This is a circus, and I'm trying to end it. Because either you took out a false statement or you're not telling the truth now.
Or your daughter could be prosecuted for false statement. She may, I think that's what you need to do. If this woman says that her daughter wronged her by filing a false statement, then you ought to have the state police go interview her daughter and address that to the grand jury and see if she wants to go to the penitentiary. Is that what you think? Wait a second, man. Don't you think if your daughter has done this to you, done a false statement, don't you think she should be prosecuted?
Yeah, because I don't
Okay,
feel
that's what'll happen then. Okay, now as far as him, this gentleman is concerned,
and I,
well, you don't say anything else. You can go back, and take a seat right back there, as a matter of fact. Now, Mr. Conlon.
I don't know why he would not have contact with her after he's been put in jail and if this is all false. But if he does, I don't think it should be a condition of his supervision that he not have contact with her because you can see what's emanating from their.
She was the victim originally, is that correct?
That's correct.
Yeah, I'm gonna add as a condition of his probation, he did not have any contact.
And I'll be contacting the county attorney in Somerset to see what happened. That he took this out.
And if you were, now after this investigation goes farther with the daughter and everything, if you want to file a motion to have that condition removed from his probation, then I'll consider that. But at this juncture, there are serious allegations about him harming her. She can't remember, and there is a complaint against him by a person who has not been disproved at this point. And I don't think he ought to be around her till this thing gets straightened out. Now, if it gets straightened out to the satisfaction of the Commonwealth or not to the satisfaction of the Commonwealth, if you want to have a hearing to reduce that thing, I'll consider it. Okay?
Yes, Your Honor.
Okay, thank you very much. He's going to be released today. The condition of your bond is you not get around that lady. You understand what I'm saying? Or her daughter. You understand? Okay. Shouldn't. You need to contact probation bureau when today.
Yeah.
When you release, is their office in Wayne County? Go to the probation and parole office in Wayne County as soon as you get released. People at the jail will be getting your order down there on the percent. Okay. Anybody else on the docket? Edward Daly. First. I guess we gotta have Edward Daly back up here. Mr. Crossley.
Judge, I'm here on Mr. Cross's behalf. I don't think the Commonwealth has completed.
You need to keep your face this way when you're talking on the microphone.
I don't think the Commonwealth has completed the paperwork.
Okay.
Mr. Stockton's looking over right now.
Okay. Yeah, Mr. Daly, if you just have a seat right over there somewhere. Come over here and have, yeah, put him back here. Mr. Amonette is here.
Yes, Your Honor.
We'll bring him around. Withdraw the bench warrant, Mr. Amonette. Mr. Amonette, why weren't you here?
I was on my way to see Mr. Cross at Probst down here at the community center. I didn't know I had final sentence. He called me and told me to come on up here instead.
That's all right. That's okay. Commonwealth versus Thurman Amonette, 23 CR 0034. Mr. Amonette, were you born in 1989?
Yes, sir.
Last four digits of social security number 8767. Were you ever sentencing? You had an opportunity to review this pre-sentence investigation.
Yes, I have, sir.
Yes, Your Honor.
Is it substantially correct? Is
Yes, Your Honor.
there any reason Mr. Amonette should not be sentenced today?
No, Your Honor.
On plea of guilty to possession of controlled substance, first degree methamphetamine, shall receive a sentence of 3 years, probate 5 years supervised. On plea of guilty to failure to maintain the insurance on a motor vehicle as required under 305, he shall receive a fine of $1,000 and costs. He shall enter and complete a special report. And is it in the special report already, drug court?
Yes, Your Honor.
She'll receive credit for time served unless you are got a job yet.
I'll start Monday.
Okay, so I'll, that'll, so fulfill that obligation. knowledge we destroy the X. Now, I'm gonna give you some time. What is the total, Mr. Bowles? And fine, you got $1,000 fine, we merge all the court costs. $1,155. I'll let you pay that at $50 a month. Starting 30 days from today. That'll give you time to get your work done. Okay?
Thank you, sir.
Okay, now, you need to be very careful when you sign this agreement. It's gonna be you're on probation. For 3 years. And you probation parole officers when we finish.
I need to go, where's that at?
Well, they're sitting right here. Now, the other thing I'm gonna tell you is this, is they are not your enemy. So you need to be very candid with them. You've got any issues come up, you need to develop and be easy to supervise. If you're easy to supervise, you get along well. If you're hard to supervise, sometimes things don't go with it. Okay? Okay, is there anything else? No, but he's gonna get, when he gets out of this, so we need this information. Get the information.
I got one other question, Your Honor. Larry gave me a paper for me to fill, give to somebody at the courthouse for them, to write my fine down on and sign how much I owe, so he'll know, like. I just want to know if I need to bring that too.
I just told you what it is. You'll write it down for me. $1,150, start to pay $30, $50 a month, start 30 days today. These people over here give the information. Is there anybody else to come before the Clinton Circuit Court on the criminal document? Yes, still waiting on that one case.
Yeah.
Well, let's go off the record.
That's hearing at 2:00.
Do we have that at 2:00?
No, that's- Oh, yeah, you're over there. Yeah, it's 2:00.
Squad. Okay, we call the case of Commonwealth versus Edward Daly, 22 CR 0018. Are you Edward Daly?
Yes, I am.
Okay, were you born in 1951?
1951.
Last 4 digits associate Social Security number 2842.
Yes, sir.
Earlier today, we found that you were competent and you listened to testimony. Is that right?
Yes, sir.
Counselor, I understand that your client wishes to enter a plea. Is that correct?
That's correct, Your
Is
Honor.
it a felony plea?
It is, Your Honor.
Now, a motion's been tendered, sir, that says that you wish to enter a plea. Are you currently under the influence of drugs or alcohol? I'm not taking drugs or alcohol.
No.
Okay, are you doing this freely and voluntarily here?
Yeah.
Okay. Now, are you the same person named in this indictment? Mr. Daly? Yeah. This is you here at 22 CR 0018. Counselor, you've gone over that with me?
I have, Judge. On our plea paperwork, it says 22 CR 13.
Okay, I got a dot there, so it probably is 13. Just look like it. Have you had plenty of time to discuss this matter with your attorney?
Yes.
Now, are you satisfied with Cross and his associate? Are you satisfied with their advice?
Yes, sir.
Okay. Now, you understand that you don't have to enter the guilty plea. Understand that? And you have certain rights under the Kentucky and United States Constitution. I'm gonna go over them with you, and then at the end, I'm gonna ask you to understand them. If you don't understand them, you can step away from the podium and ask your attorney, okay?
Okay.
You have a right not to testify against yourself. No one can make you say that you have a right to speak trial or jury, right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you, right to use evidence, right to call witnesses in favor. Right to bill this matter to hire for you to lose, right to further conduct through the unreasonable that which you're guilty of charges against you. If you understand that by entering a plea of guilt, you give up all those rights. You understand that?
I understand.
Okay, now I may consider the Commonwealth's recommendation that I may apply any range of sentences allowed in the law. Prior to accepting the recommendation, I will ask to wait for a pre-sentence investigation report that you need to look at to see if you agree with it.
I agree.
In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you'll have the right to withdraw your plea. Okay? If you move to your left,
Okay.
Mr. Gordon Anderson, will you give us the recommendation of Commonwealth? Will you listen to this very carefully, sir? Go ahead, Mr. Gordon.
Upon a plea of guilty to wanton endangerment first degree, 4 counts, the defendant shall receive a sentence of 5 years on each charge to run concurrently for a total of 5 years. Upon a plea of guilty to criminal mischief first degree, the defendant shall receive a sentence of 3 years. These 2 sentences are to run consecutively for a total of 8 years, probated for 5 years. Probation is to be supervised. The defendant shall receive credit for time served. The defendant is to pay restitution in the amount of $600 to Jonathan Cravens in the amount of $50 per month to begin within the next 30 days from the entry of this plea and on the first day of each month thereafter. The defendant shall not have any firearms on his person, residence, or vehicle. And it is
Is that what you agreed to, sir? Is that what you agreed to?
I agree to.
Okay. Now, if you got the paperwork, who's got the paperwork?
I have it.
Is that your signature on there? That's your signature? Is that your signature on there, sir?
Huh?
Is that your signature on that document?
Yes, sir.
Okay. Now you understand that after entering this guilty plea, if you have felony convictions in the future, you'll get a tougher sentence if you have another felony. You understand that?
Yeah.
Okay. I'll accept the agreement order PSI. And is this a probated sentence when it will be?
Yes, Judge.
Okay, well, we'll sentence you on November the 2nd. And you ought to be able to get out that day, on November 2nd. Okay?
November 2nd.
Okay, okay, thank you very much.
Thank you, Your Honor.
Is there any other matter to come before the Clinton Circuit Court? If If not, we'll stand in recess till 1 o'clock. Thank you. Cabinet versus Skipper.
Your Honor, in this case, non-custodial parents are ordered to pay $300 a month on current, $50 on arrears. The arrearage amounts to $1,535. We're asking $350 by November the 1st.
Thompson, Cabinet versus Thompson.
Your Honor, in this case, we have an agreed order.
Orton versus Orton.
Judge, we have an agreed order in this case.
Yeah, I just started Garson with her last week. I had to pick it. Garson, I didn't know why, and I didn't know. I thought, if I'm a motion, they'd come up like this to do. You know, that same dialogue, your Honor, if you receive that one.
What's
The custody, we won't have anything with custody.
Oh, they don't be here today.
This is just
Oh,
the
just
child.
wait up here, we'll talk about that.
Yeah.
You have an agreement on this, that's why.
Yeah, on the agreed order on the child support, but obviously nothing on
Are you
custody.
garnishing his wages, or you do a wage assignment, is what it is? Right. Is that right? So
Yeah, I know it was supposed to be mailed in, but they've already started taking it up to, I know the agreement was to be mailed in.
okay. All right. Now, if you've got issues about your child custody, you need to get an attorney to file a motion.
He filed some pro se motions and they weren't noticed for specific time. And Ms. Bly represents the petitioner and she is out of the state today and she requested that it be scheduled for November 2nd, so it's supposed to be November 2nd.
You, when you file these pro se motions, you've got to make sure that you put on the bottom of it, serve the attorney for the other side and give them notice.
I answered.
And then, but the problem is usually when that happens, the attorneys or someone contacts each other and says they've got a conflict that day. Well, evidently she's out of state. I don't know why she didn't contact me. She certainly can serve. When is she gonna be back? So is she gonna, she's out of state.
Here's what I said.
My great motion with that, the 25th of November.
Where are we next week? When are we back here? In Cumberland before we're back here? It's about 2 weeks. Yeah, the motion day here is earlier than it usually is because of the calendar. So what is it? What is that motion day? November 2nd. It's already set.
It's set.
So you're set for November 2nd.
Okay, so it wasn't the day for that.
It says November 2nd. Yeah, it was probably set and they moved it to the next room.
So we November 2nd.
November 6th. I would suggest you get an attorney.
I'm trying, Your Honor, with this, all the fines, and I'm trying, you know what I mean?
Yeah, well, I would go to surrounding towns and check out, sir, okay?
Yes, sir.
Okay, thank you.
Thank you.
Did we get to Shelton?
Shelton. Yeah, we're gonna renotice Shelton, Judge.
Okay. Hall, Kevin versus Hall.
Judge, this is a motion for default judgment. Served with a complaint on August 16th of this year, and we have received no response. Asking pay $216 a month on current and 40 on arrears.
Sure, sir. Service correct on the yeah, you serve. What's the case number?
It is 23 CI 73. And
Shows you, so it's 16 there.
August 16th.
Yes.
Yeah.
Okay, that's fine.
Thanks, Judge.
Did?
We have White versus Garrett. You got an agreed order in that, Your Honor.
Henry Gordon Anderson was the assistant county attorney, Cumberland County, now she's.
He told me he got an assist.
So we just had two cases on child support docket, that's the first time she told it for me. And I told her I had to look back there, and I said, I thought Lindsay Bell was working. Two cases.
That's funny. Hey, Coleman's a good guy. I like Coleman. We've already worked with each other on some stuff.
Okay, thank you very much.
Thanks, Judge.
Had to wait till 1:30. Oh. Special session around, what? First case on the docket is Claiborne versus Claiborne. Notice that's passed over, redacted, is that correct? The South Capital Partners versus unknown heirs of someone.
That's a Danny Russell case, maybe.
There's a Danny Russell.
Yeah. They were called, withdraw that, didn't it?
We'll get behind the docket. Are you involved in this case?
Well, I've negotiated a settlement with them on behalf of some of the
So
defendants.
you're kids.
I'm kibitzing, yeah.
So you're representing the plaintiffs want to withdraw that subject motion?
It's mine. I spoke with Mr. Patterson, the attorney for the plaintiff, and the matter will be resolved. He was going to request that it be passed because we're going to buy their, going to buy them out, going to buy their position.
Mid-South Capital versus Charles Winkle and others. So that's different attorney.
Yeah.
Opposition here to it. I'll see if there's an order in there. I'll sign it. John Roberts. Others versus Teresa.
Mr. Little says we need an order of distribution, and he's correct. I can't have no words. The last one I had, I didn't know what I was supposed to do, whatever. I mean, you just take an order and sit there.
How much money is involved?
So it was approximately 34,000 that's left, and I just put those percentages to make it easier for Norbert. Because I put some figures on the motion, and he may have collected some interest a little bit, so
Correct.
the percentages be better, I think, for him.
So the distribution will go to the Cullivers and to Roberts, and just to mail it to y'all, or y'all will be included? in the check. The reason is this is unclear to me because it says care of, that could be delivered to.
That just means it's to be delivered to me.
Is it- it's- okay. Steve Byer and others against Gary Wallace.
Good afternoon, Judge. Steve Wallingford about the plaintiffs.
Just the charcoal.
It is.
Yes, Your Honor. We have two motions on your, one is a motion to compel. Me and Mr. Cross have met. Mr. Cross agreed to provide that documentation within 21 days.
That's correct, Your Honor, and I'm
just. What's your other motion?
Your Honor, we have requested a receiver in this particular situation. We have come into information that we believe is very alarming with respect to the management of Dale Hollow Trust.
Mr. Ross, will you move over this way? Council, you move behind me.
Certainly.
Yeah, I'm having a little bit of trouble. I read the motions last night, but I didn't have the file with me. And it was a little sketchy. I mean, we've been here before.
Yes, Your Honor. Previously, we were here on a motion for leave to file an amended complaint
Right.
to add as a supplemental party J3.
Yeah.
J3 is an entity that appears to be owned by Mr. Wallace, practicing the sale of charcoal products on Dale Hollow Charcoal's premises, selling Dale Hollow charcoal with Dale Hollow charcoal equipment and Dale Hollow charcoal employees, but yet receiving over $500,000 from former Dale Hollow charcoal clients or customers.
Where did you get this information from?
From subpoenaed bank records of J3. We provided that documentation to the court.
Yes.
This particular situation, as we've raised both in our our motion for leave and this motion for a receiver is incredibly alarming to us. We've requested that a receiver be placed over both Dale Hollow Charcoal and J3 in order to protect these assets as interim relief while the parties proceed towards litigation.
Do you propose that the operation of the plant continue, or are you trying to close the plant down?
Your Honor, we're not trying to close the plant down.
Sort of receivership just over in proceeds of sale, or what exactly? I couldn't get detail. I don't remember detail what you want the receiver to do.
Your Honor, we want the receiver to receive the accounts of Dale Hollow Charcoal and J3. We want them to be able to make determinations about the validity of business expenses that are incurred on behalf of these companies. We want them to be able to report back to the court their findings as well, in order to manage those funds and those assets as we go forward with litigation.
Mr. Charles?
Yes, Your Honor, if I may address the court. Your Honor, a little background is appropriate, I believe. And to explain why the discovery has not been complied with ties into all this. On July 31st, I believe it was, they serviced with interrogatories, discovery requests. They then sought and were granted leave to file the amended complaint, adding this additional defendant, which is a company owned by Mr. Wallace's son, and which basically conducts a bagging operation at the site of Dale Hollow Charcoal, and they sell the product.
Where do they get the product?
It's made here.
Same plant.
Yeah.
Same plant makes it, but you just got client's son who's operating a business, and they go out there and bag the same charcoal and sell it to somebody.
Well, that's the retail aspect of this through an independent, but it's one of those things where they're related by blood, but they're independent companies. But Mr. Wallingford has decided to, understandably so, bring them in and let's sort all this out. And that's sort all this out is the most important aspect of this. We elected to wait until the third party was served before we could meet with them. They have their own attorney. I think Mr. Wilkerson's probably going to represent them, but they were only served the process on October 6th. Now, Mr. Wallingford has access to a lot of bank records. There's never been an effort to conceal anything. This is where it gets a bit complicated. This is a part of what the court's familiar with as the old refinery property. And Mr. Wallace has a purchase contract with Anthony Wilson. And Mr. Wallace has done nothing but work in charcoal plants for many years.
Okay, that's what I was getting to. I'm very familiar with Dean Jordan. Dean Jordan Ford used to be, that's the more down before, because the late Richard Jordan was my college roommate. He's deceased, and I haven't been deceased for a long time, but I'm aware of their firm, and I don't know very many people at that firm who are prepared to take over Dale Hollow Charcoal.
But Your Honor,
And that's where I read it. Am I wrong?
well, Your Honor, they would be, the receiver would be not on the ground supervisor. They wouldn't be at the facility. We see
This
them.
receiver shall be entitled to immediate exclusive possession, custody and control of the property. It shall be entitled to immediate possession, control of all books. So it's not just the books or the next part. They're responsible when I sign this to take over the property, or they can take over the property, which would include the operation of the charcoal plant. Isn't that true?
Your Honor, they would be the overseer.
But it doesn't say that here.
Well,
Does it?
And
If
if,
the defendants, Dale Hollow Charcoal and Gary Wallace, and Jackson Wallace are enjoined from possessing, operating, or managing the property. Well,
Ron, may I?
I'm just asking what it was first. Might be something y'all agree on, but it looks like to me that Dean Dorton and Ford are gonna have to get out of white shirts and put on the helmets down here, you know. and
Your Honor,
it's a
yes.
long way from Lexington to this portion.
certainly, and the order is a proposed order as well. And
What?
the order is a proposed order, but we certainly think that we could make that amend it in order to meet this court's ruling.
Well, let me tell you what I know about the charcoal business. I know that the charcoal plant in Somerset, which is a pretty good size charcoal plant. What is the big Kingsford Charcoal, which is owned by the Clorox company. And it's probably the leading seller of charcoal in the country. It's closing down. So I think the charcoal business is a little shaky because unrelated to this, I was just wondering why they put all that money in the charcoal plant there. And that's a very important use of secondary wood products for our economy over there. I mean, you go over there, if you haven't been through Sunshade and see the piles and piles of sawdust, which used to be abandoned and thrown away, and now they make the charcoal. So I'm a little scary about, from my experiences in the past years ago when I practiced all about getting receivers who didn't know anything about the underlying business closing down. We used to do that in the oil and gas business. People would file these, these lawsuits of rescission on state securities law. And the receivers would destroy the property. By taking it over, they didn't know that they were like little shallow oil and gas wells, and they didn't know how to run.
Yes.
So I don't know, I'm not, if you need closer supervision of any sales, closer supervision of any monetary things, I'd be probably inclined to give you more of that to see what's going on. Mr. Cross has given an explanation. I can understand why that's not plausible for you. If you're on a charcoal plant and they're out there bagging charcoal out of the plant, what you're doing, and related kind of selling to somebody, that's my heckles a little bit too.
Yes.
So now, Mr. Cross.
Yes, thank you, Your Honor. Your Honor, I suspect, I have reason to believe that Mr. Wallingford's proposed receiver, who I am not familiar with, would attempt to retain and hire Mr. Wallace to run this operation. Mr. Wallace is not required to do that, okay?
Right, especially if you can be completely excluded in their
Right.
list there.
Here's the other real complicating factor is if there's a receiver appointed, it has been stated by Mr. Anthony Wilson that the land contract, which is currently in default, will be terminated. So here's David Cross's thoughts on this as to how we ought to proceed. I do believe that we ought to be able to get the third party in, comply with their discovery request in a timely manner. And if he wants to press his motion, then I think it's going to take a full-blown evidentiary hearing regarding this entire situation. This is
What
going.
about mediation?
Well, let me tell you about that, Your Honor.
Okay.
We attempted to mediate this case
Who's the mediator?
informally, and informally means without a mediator, but with counsel. And
That's not mediation.
well, we understand it ought to be mediated. I'll just say this. Number one, that was unsuccessful. Number two, people have to come in to a mediation with the proper frame of mind if they want to settle a case. And my
Well, that's
client's
what a
prepared
good
to do that.
mediator does. If you get a good mediator that looks at them objectively and is able to tell this gentleman's client something that he really can't tell them. You know, he's their advocate, that sort of thing. And, sometimes, or maybe that you can't tell your clients, or that your clients aren't willing to hear unless they get someone of high repute that's done a bunch of these business-like mediations and can take a look at the lay of the land and look at things like the land sales contract and property and the facility being seized the facility, you know what I mean?
Yes, sir. I think the court has a real good understanding of this.
Sometimes people make bad investments. And they get defrauded and it's hard to extricate themselves. I'm willing to try to do something to take cash flow.
Your Honor, and that was the intention of the motion, is to protect cash flows.
Listen to what was said. If you talk about doing a cash flow, maybe Mr. Cross's clients want to lay down and let the place close, or let Mr. Wilson come in and throw them off of it. And then your clients have nothing.
Your Honor, as far as Mr. Wallace abandoning the business and Mr. Wilson declaring breach on the land contract, I think that those are risks that we have weighed and taken into consideration.
You need to go to mediation.
Well,
And see if y'all can buy everybody out of it, to leave everybody with their heads up and their charcoal intact.
And I understand, I guess from my perspective, the purpose of the motion today is to really protect those cash flows and express those concerns. Well, I understand that court's interpretation. Is Mr. Cross had mentioned a hearing on this matter? Would the court be willing to schedule a hearing?
I'm willing to schedule a hearing, but I think I understand what's going on here without. But I'll schedule it here. But what you need is a resolution to protect your clients and your money, and get the money back or get something back or watch the cash flow. I really, and I don't know if in detail, it'd be hard for me to convince that there's no separation between these people. That even though they think that they don't think they're having nefarious purpose, I'm not accusing them of that. But there's no separation of other people back at Charcoal and sell it right out there on the same location. I don't know that. But even if you get to that situation, I won't ask you how much your clients have invested in this, but I'd say pretty good chunk of money.
But Your Honor, we've already disclosed to the court that it is a chunk of
I know,
money.
but we're being broadcast.
Yeah.
So I'm not asking.
Certainly.
A pretty good chunk is nobody in this case really wants to discover how much money Shane's in what's been invested.
Certainly.
Your Honor, let me interject. Mr. Wallace would like a resolution of this too. And at some point in time, we want to mediate. If it's time to do it, if you want to order us to do it, that's fine. I think he's got to get some discovery.
But, okay. Well, let me ask what the deal is. Does the discovery you want this thing have to do with cash flow and sales and what kind of stuff is it?
It is discovery targeted at Dale Hollow Charcoal, and it is about loans that we have made to Gary Wallace in his individual capacity on behalf of the plaintiffs, Twin Oaks and Steve Fire. I apologize. It is about loans that we have made to Dale Hollow Charcoal on behalf of both Twin Oaks and Steve Fire individually. It is about expenditures that lack business necessity that Mr. Wallace has taken out of the business. And it is about other charges as well that we have additional questions about that lack sufficient documentation.
Well, you know how much money your clients give, and you want to know what they did with it. So, right?
Well, we want to know what
You know how much money your clients give. Loan, you know that?
Well, of course, sure.
Of course.
Yeah.
So what you want to know is how they disperse it, what accounts they went to, how they disperse it.
Exactly.
You understand that's what.
I do, Your Honor.
You get behind the microphone.
I do, Your Honor. And I would remind that we do have this other defendant that's just only been served last week, and we're going to have to get them in too because
What do they do in this?
it's a bagging operation.
That's owned by.
It's owned by Mr. Wallace's son.
Well, I don't think you have to go very far for them to get their information.
Well, they're on good terms, and I think, I think the records will be
I'm not
subject to
accusing them of
scrutiny.
doing anything that they think is illegal. There, as far as any criminal action, I'm not saying that, but I am saying that there's been charcoal and stuff evidently sold by someone off the property that these people think they own the manufacturing to, and they didn't get any of it. So, you know, what can we do that's the least interference with the continued operation of the charcoal plant that will assure them that any future sales are reported to Summit? I don't know what a friend of the court would be. What would be the term of someone that was working for the court? It's not an outside.
Well, it's usually something that the master commissioner does.
Well, you have special commissioners and things like that. I don't know. I don't think friend of the court.
I think when I was master commissioner, on a couple of cases, it was up to me to review.
Well, let me get someone, an attorney in the area that's not connected with any of these people that you're in, that would be in charge of these reports coming to, and you need to delineate exactly what you want that person to do. I'm not gonna let the person go and take over the plant, but I will give the power to that person, whether it's, I've got a mental block of what you call a person like that, when you from the court or some kind of commissioner or something. I'll get the right number and coach you later.
Your Honor, and just, I mean, I want to make sure I understand kind of your ruling today, which is that.
I made it, yes.
Well, let me, if I want to paraphrase, but not incorrectly paraphrase, my understanding is that you're going to identify an individual to oversee these accounts.
Conservator?
Lance says conservator. Buzz didn't know. I'm crestfallen.
Buzz knows, but you have to pay $10,000.
The clock is running while he's sitting right there.
I would say, I don't want to make it a conservator because I don't want the person having responsibility to run the thing. Okay, I want, daily reports about how much, what they're paying for raw material, what they're selling, what the cash flow is going on. And I want it to, by someone that, is kind of above reproach. It's not going to use that proprietary information to feed it off to somebody. You know what I'm saying?
Your Honor, I appreciate it. Yeah. And I think we would be agreeable with that proposal as well.
Well, does my master commissioner have any conflict with these people that you know?
Well, he's represented Anthony in the past. I don't know.
I thought he might have said.
As we all know. Represented Ewart, I'm sure, have you?
Absolutely. One of my most memorable clients.
Oh, man. I don't know, Mr. English could probably do this for a reasonable fee. He's got over there on hospital business all the time. They represent Mr. Wilson as well.
Both of them are sports people for sure. Let me, y'all draw an order up, see if you can go back to that reach an agreement on what sort of information it should be. I'm not just talking, I'm talking about information about intake, raw material, output, charcoal, what the sales are,
Yeah.
the sales were made to. And then the discovery would take place from this point before this officer of the court at this point. You get complete discovery, and after that, you get weekly updates, that sort of thing.
Are you, mentioned the word disclosure, are you, you're separating legal disclosure, but the information contained in that
discovery, I'm talking about the operational disclosures of how much raw material they're taking, what the cost of business is, who they're paying for labor, who they're selling stuff to, just pretty much everything that partners should know about what's going on in their business.
Certainly.
And we'll assume, for the purpose of this disclosure, that everybody that buys charcoal out there needs to report it, whether it's son or some other associated company or whatever, there needs to be an accounting of what they're selling to see if they are selling the charcoal to some other entity. What's the markup when they're selling it to somebody else? You see what I'm saying? You can sell it for a $10 bag of charcoal to an associated entity for $5, and they're being selling it to somebody else for $10.
Certainly.
In other words, yes.
And now that he's got the other party in, I think he's entitled to all of that information. I mean, we don't have any reservation at all.
Well, I think he was entitled to all of it, what your client, as far as what they were selling it to, and who they were selling, and what they were getting.
He's had pretty good access,
Well,
I'll say that.
Yeah, I'm not really in this case too much yet. So, let me try to think of, I'll try to think of someone in surrounding counties. Y'all just see if y'all can draft up the wording of an order that's agreeable to both of them, that you comply with, and leave the name of the conservator or regular court. What's the credit court? There has to be things, you know, but there's some phrase in some of these places that they have conservators that of course have a lot of business things that they do. I can't think what it is, but we'll call it what we want to as long as we describe on powers.
Ombudsman.
The what?
Ombudsman.
That's somebody takes complaints. There's some language that courts have that's some officer that had regular. But anyway, it's on one line. $10,000 or 15 bags of charcoal. Whichever. And y'all get together before we leave here and see if you reach on the group. Certainly. Bring it on the record and then y'all can produce it for my signature.
Certainly, I appreciate it.
Okay. Okay, Wilson versus Sutton. Wilson versus Sutton. Your Honor, we proudly.
Your Honor, I know you feel like you're going back in time. We've had one of the Wilsons in the last case, and now he's back in this one. So lo and behold.
Takes a long time to settle some things. Okay, now this is a situation where you had someone that had rights of development on the property. And one of the parties wants to go and do that with roads and things like that, and they say it's expired. Is that correct?
That's correct, Your Honor.
You want to talk about that?
Yes, Judge, this is my motion to dismiss based on the statute of limitations, failure to comply with that. The court can see from the pleadings, including Mr. Cross's response, that this was a contract entered into between my client and Mr. Wilson, I should say my client and her husband at the time, and Mr. Wilson, back in 1997. And essentially, Mr. Wilson was to do a number of things to prepare a tract of land to be a subdivision, run roads, install tile, several things under the contract. And
was supposed to.
My client was the owner of the property, and so Mr. Wilson was as part of the contract to perform these duties.
7 couples on the property.
Correct. Yes. And at the end of that, once those were finished, then Mr. Wilson would be granted a 1/2 stake in the property. Unfortunately,
Mr. Wilson.
Sorry.
You're Mr. Wilson.
Yes, sure.
Do you want to tell us what your client did and why you think the statute of limitations told us?
Well, Your Honor, we have in the record, we have Anthony's affidavit, which says that substantial work remained to be done, including rock on road, needed to be an entrance off 127 that was never built. It was not subdivision ready at all. And most of Anthony's contact came through another name out of the past, Rosalie Sellers, who was Miss Sutton's mother.
She's still alive?
No, she died in 2018.
that will be disturbing news to her since she's sitting right there.
It's only happened twice in history. We witnessed it. Yeah, so.
She moved in two
It
thousand
only
eighteen.
happened twice in history, Mr. Cross, and here's your example here. Congratulations on the resurrection.
All I'm gonna say is that's when Anthony lost contact. Okay, she moved in two thousand eighteen.
Kind of cast a lack of credibility on the rest of your search.
Sorry. Well, I don't read my own documents very well. Your Honor, this was just left hanging. What needed, of course, the Suttons got a divorce, and then Miss Sutton's placed this over into an LLC. And it just appears on its face that Miss Sutton and her company have just intentionally just deferred doing anything and put it off and put it off. And finally, Mr. Wilson decided to force the issue, and lo and behold, Mr. Venters understandably has raised a statute of limitations issue, because unless Anthony can come in and prove and document that the work was not finished, and or that he was told it was finished, then the statute of limitations argument would apply. I believe at this point in time, this motion is highly premature, and I think what we've got to do is take some proof via discovery, get into the discovery process, and just see what these people say about what happened and what needed to happen. And we believe we can overcome it.
Take me back a little bit to the beginning of this thing. Okay, let's go back to the expectations of the parties. Now, you represent the Wilsons.
Yes.
Whose property was this? It was a Sutton's property.
Sutton had bought the
Okay,
property.
Sutton's property.
Yeah, Sutton, it's in Desda, and it's near the lake.
Okay, so
Okay.
Sutton had bought the property. Now, did Mr. Will, what kind of consideration did Mr. Wilson pay the Suttons, and what do you expect to receive for that? Be sure.
Your Honor, he received no consideration.
He gave no consideration. He didn't own the property.
The Suttons owned the property.
Yeah, I'm talking about what did Wilson, who did Wilson?
Wilson built roads, did improvements, and in return for that, he was to receive a 1/2 interest in the property.
So he was to do the improvements.
Yes, he's not received anything.
Okay, well, and they claim he didn't do anything.
No, they
Well,
claim.
that's what they claim.
No,
Very little,
No.
very minimal.
No, they claim that what Wilson did was long ago. There's no question that he did substantial work down there.
Well, I think the word substantial is in question.
Well,
My client says he.
We're substantial, it's not, we wouldn't say what's substantial, but you felt like that he did the work necessary and they failed to refuse to convey the property to him.
No, he did.
No?
He did substantial work, but the work was never finished. He was never authorized or told to go in there and finish the work.
Why would he have to, if he was finishing the work in order to get a 1/2 interest to the property, then is he claiming he's entitled to be reimbursed for the work that he did, or that he should be able to go in and do more work and get 1/2 the property? What relief does he want?
He wants, they're saying the work.
No, I'm not asking what he's saying, I'm asking what.
We want a deed for 1/2 the property.
Well, but you admit that you haven't done what needs to be done, so you're not entitled to a deed to that. So who's gonna define, I'm just making this for the point of argument. So how much more work do you think that your client should do? If he thinks he's already done enough, which is not enough to drop the property, he already done enough to get half interest in it. When he gets half interest in it, he'll have very little incentive to do anything else.
Judge, if I could interject very briefly, I think the problem was, there was a couple weeks worth of work done here, and this project was solid rock. They could not run water lines, they could not do.
Mr. Wilson.
No one could.
Well, I know, but
Yes.
it's his obligation.
It
to do
was,
that.
it was, yes,
He
yes.
gets half interest, and you're saying that it ended up not being able to be done.
That's correct, and the project
You
was
have an outline
abandoned for
of-
that reason.
You have an outline and an agreement of exactly what improvements he was supposed to make to it to get a half interest.
It is in the contract, it is, right?
Okay, well, that.
He acknowledges he didn't do it, though.
Well, I understand, but I don't think I've seen the contract, was it attached to?
Yes, Your Honor.
It's attached to the complaint.
And it's in our,
I didn't see it.
it's also in our affidavit, and Anthony's affidavit, it's set forth very clearly. He was to build roads. There wasn't
Say how-
anything
what
said
kind of
about a
roads?
water line.
Well, does it say anything about what kind of roads?
See, that's what you get into in these deals.
Yeah.
Hey, Judge,
Blame it on the lawyer who did the contract, that was me.
well, there's a really important fact that hasn't been brought out here yet. And I really think it's dispositive. In 2001, Mr. Wilson took the fairly extraordinary step of recording this contract. And there's only one reason he would have done that. It was 4 years after the project started and 3 years and 50 weeks after it stopped. He recorded it because he was afraid that there was a problem. He recorded it because he knew this deal was off. And that was 22 years ago, Judge. We have a 15-year statute of limitations. He recorded this contract 22 years ago. At a minimum, that's when the statute started to run. That's when he made.
Your Honor, I guess after 4 years, I guess Anthony did get a little antsy about what was.
What do you say about the 15 years? This is not a court of equity here. It's making a legal argument.
Your Honor, that statute is on point, but our position again is the work wasn't finished. The roads were roughed in.
I'm not talking about the work or anything. His argument is that a 15-year contract expires, the statute of limitations due to contracts in place, and after 15 years, you can't enforce the contract.
But Your Honor,
How do you get around that?
his cause of action didn't accrue until he completed the work.
That would be, we get into the rule of perpetuity. That's the case. It would never accrue unless the whatever work was never.
Well, then at some point in time, you do what Anthony did. You go ahead and file suit and try to see whatever the party's rights are. Again, these roads were roughed in. It said he's supposed to build roads. At this point in 1997.
This property was worth a lot more than that.
Undoubtedly, yeah, it's not a real good piece of property, but it's not bad.
Good enough to find out.
Well, it is. But Your Honor, I think everything Mr. Vendors and I are talking about is factual.
Argument about why the statute of limitations doesn't apply to this case.
Because it didn't kick in until the work was done, until it was finished. He says it never was finished. He was
I don't
stalled.
understand why the contract would kick in until the work was finished. Explain that.
It's the date of breach. That's when the 15 years.
Your Honor, Mr. Wilson, it says, upon completion of the work, Sutton shall execute and deliver to Wilson the general warranty deed. The work was initiated, the work was performed.
Well, wait. So let's say it was initiated. To enforce anything, it's the only thing you could enforce would be that he was breached the contract and not win the property. Or if he was entitled to be compensated for the work he did if he wasn't able to build a contract because of some situation. Kind of on marriage sort of. Now, the contract that you're trying to enforce had to be initiated within 15 years of the initiation of the contract.
No, 15 years of the breach. 15 years of the breach, I think, is the rule.
Well, I know, well, we're talking about the initiated 15 years from the contract.
Your Honor,
when is that time?
I compare this to an ouster. You know, there has to be some positive action by somebody to trigger an ouster. This was just left hanging. Anthony,
This is what we refer to in the drug county as a job that
absolutely.
should never be entered into, could never be measured.
I don't disagree with that. I just,
Let me see the contract you got there. No, that's when you might want to.
Here, you want, this is the better copy if you want to do that.
That's okay.
I mean, you can read this one really, really
This
easy.
is just like I read it.
Okay, good.
was this deed exhibited to it at the time? No, didn't say anything.
I don't think so, Your Honor.
So this wasn't a reportable document, except it says it's filed here. They put it in miscellaneous book, or where did they put it?
I think so.
Yeah, I mean, it's got a stamp on it, that said it was filed, but obviously it's not notarized.
No preparation stamp. I know.
But it's true.
My point is, Judge, he knew that there was a breach, if there was going to be such a thing in 2001. That's why he recorded the contract.
That's a question of fact,
You
Your Honor.
know, I don't think that goes. I understand that's what you believe, but I mean, I don't know, he might have had some kind of terminal illness, I don't know, or something was wrong. Is he still alive? Mr. Wilson?
Anthony, yeah.
Well, I just want to make allegations equal both ways.
That's fine. That's fine.
Okay, now let me ask you this. Is there any amount of development of this property pursuant to this contract that would satisfy your client?
The property is undevelopable, Your Honor. It is pure rock. There's no way to, there's no way to get
Subdivided.
utilities. It can't be subdivided. It was not subdivided. None of the things that were supposed to happen happened.
You did a perk test and do any.
Right.
That's what I'm getting to.
Mhm.
If it can't be developed and it just needs to be sold as raw land, is there an amount that your client would take to compensate for the work he did all those years in this thing, or do they want to buy these folks out?
Your Honor, Mr. Wilson will go in there and do more work. He will agree to be paid for what he's done, or he will buy them out.
Well, you know, the problem would be is with this very obscure sort of amount of work it's necessary. I don't know whether you can do the amount of work to get them to the point where they're going to give you half the land. That would have been a problem anyway, that even if it was done properly. You know what I mean?
Yes.
With what you're doing. Was this during the oil period, or it was right after the oil, it's after the oil period?
A little bit after.
10 years after, but there was still a lot of deals being done on. This is probably one of the most complete contracts that's done.
Right. Well,
I-
and I'm not sure if minerals are good. I don't know. I haven't done mineral type long. If you get down in there, you gotta be careful.
Well, it doesn't say anything about.
No, but you're saying you can dash about the old business. I mean, anything's got a value.
Maybe this contract does. I don't really know. You say the law says from the breach, and so you think Mr. Cross says that you'd have to take testimony to see what the breach was. Is that what you're
Yes.
saying? When you started with the office, this was 1997, 2007, 2017.
26 years.
Well, Mr. Sutton's living, Mrs. Sutton's living, and Rosa Lee's living.
So something's good has come out of it.
And that's kind of my point, Judge. The court would have to come to some finding that the statute didn't start until 11 years later, after this contract was signed and the work was done. I just.
Well, we have to decide when the last attempt. It almost be like a material misleading or something. If they look back on it, and did a little bit more to refresh it, you know what I'm saying?
Yeah, I'm certain that didn't happen, though.
Well, can you ever tell what testimony?
I understand.
One of these things. You want me to assign a mediator on this thing, so y'all can mediate?
It's a grand idea.
I don't mind that, Judge. I'll talk to my client. Certainly, I haven't.
Everything, I mean, they might, if this is such a sorry piece of land, they might be willing to get rid of it.
Oh, I mean, he probably pay us to take it off their hands. I don't know.
It's a shame you had to pay taxes on it.
Well, that was another point I was going to make. I don't think Mr. Wilson has contributed any of that. With his ownership claim of the property. So.
This is like that last case. This is one people need to sit down and try to resolve if they can.
One thing common between this case and last case.
Two things, David Cross and Anthony Wilson.
Well, I was trying to, Bobby Richards. You know Bobby Richards?
Yes. Or Dodie George crossed my mind too.
I was thinking of somebody, Dodie George, my classmate, he's wonderful. I just don't know whether he has any dealings in oil, gas, or land or transactions like that.
Bobby'd be great, but it's whatever.
I don't mind. Either's fine.
Let's do an order of mediation this thing and let Bobby Richardson. And I will tell you that if anybody can come up with theories about statute of limitations, things like that, at least Mr. Richardson, he'd be right on top of all that. But he'd also be able, I think, to work out a thing. I mean, my goal here is to end this particular thing without anybody being a huge loser in the thing, because I think that the evidence could go either way. And if it does go either way, then we still got a mess at it. So let's say that the statute of limitation, I rule has, it's not preclude you from proceeding this thing. Then you got two people with a piece of property that you say can't be developed, and there's no definition of what kind of development should happen. I mean, this thing needs to be settled. So give me an order. I'll do a mediator. We'll try to come to some resolution.
We'll draft an order, Your Honor.
Okay. Circulate it before we send it in. We don't like to leave these out of town lawyers out of this.
What about out of town lawyers?
We don't want to leave them out. Make sure he's following
No.
his satisfaction. Not the order.
Benders is an honorable man, and his father was before him.
I understand.
Yes.
I understand. Okay, thank you.
Thank you, Judge. Have a good day.
21st Mortgage Corporation versus Ron Cole. Is anybody here on that case? It's a motion for default judgment. And I'll take it under advisement. Let me see if the service is correct. Okay, anybody else? Does anybody else have anything that's been brought before the court that wasn't on the docket?
Afternoon, Judge.
What do you have?
Judge, me and Mr. Carroll are co-counsel with April Wimberg from Denton, Bingham, and Greenbaum. We represent the Journey Pure Bowling Green et al. And we thought we had a motion on for today.
It's okay, we're here.
I think Ms. Wimberg's going to argue the court.
I'm not, obviously, I don't have a motion, so just give me some back.
Yeah, no,
I
well,
have a copy, Judge. Have my copy.
well, Your Honor, please, my name's April Wimberg. As Mr. Turner said, I'm with the law firm of Denton's Bingham Greenbaum Dahl. We have represented the defendants across the country.
Oh, I know what this.
Yes, and in this motion, Your Honor, there's a lot to unpack here. And I apologize, and I don't want to repeat any facts that Your Honor knows, but.
I don't know anything about.
Well, perfect, perfect. Well, then I'll.
We've been here before.
Well, Your Honor, actually, and this is there are 4 defendants in this matter. Only 2 were served in this case. And there was, and I would say, Your Honor, which my motion put forth is there was a mistake. I was in Bowling Green defending Journey Pure Bowling Green. And it's on the docket. I put it on the docket. I was very active. I was active. And Your Honor, and so the miscommunication came when this complaint was filed. There were ongoing settlement negotiations between the parties. And
did you get a judgment signed on this? Is that what?
Yes, sir. Well, what basically happened, I filed a motion for default judgment. You indicated from the bench it would be granted. We never received it. We checked the court file. There was a note from the circuit clerk saying motion granted. We then filed a motion after they filed an answer to strike the answer and to enter the default judgment back on August 10 that you said you were going to grant. That order was signed by the court.
And Your Honor, we never saw that.
On that, the first order that was tendered had blank amounts on it, so that's why that order was not signed.
And the reason I had done that, I think that,
What did I sign there?
the same order with just the amounts.
with the amounts.
And Your Honor, that was after our answer was filed. We were never aware of a default. And again, two of the defendants were never served in this case. And so
Was your client served?
to do with I represent all four defendants, Your Honor. I'm representing all four defendants. We filed, as soon as this issue came to our attention, and again, I put that on the record, Your Honor, I filed an answer within 24 hours. I contacted counsel and said, I put on the record what I said. I said,
How
it
much
was a
was your check?
mistake.
Excuse me.
Was it essentially for the
For the rent that's due on the bill.
It was not for your, it was for future rent in Your Honor, and there are legitimate defenses in this case. And if I could give, even just Your Honor, the timeline for the how we got here, again, I'm not saying that there wasn't a mistake. There certainly was a mistake in communication. And
You served it on their agent for service process.
Served it, I talked with their lawyer, had a Zoom call with a different lawyer, I believe, in Pittsburgh, that's Matthew Clark.
Yes.
And told him, look, here it is. I served him with the motion for default judgment saying, we've got this coming up, and heard nothing back from him. Frankly, I thought it was a situation, we haven't been paid for the property that they leased since October of 22. And all we want is to be paid. The lease has an acceleration clause that if you breach it, you got to pay all of it. And that's why that's how we're here. Yes, sir.
And Your Honor, and again, I'll say
So
this.
you have no defense at this juncture because you missed the deadline.
But Your Honor, and this is the part where, and I would respectfully say, Your Honor, what happened was Mr. Clark contacted the defendants and said, Journey Pure Bowling Green is filed this. And they said, April Wimberg is in settlement negotiations with them, which is a true statement. And it is on the record where I was settling a
So
case.
there's litigation over in Bowling Green going on. What you're saying is they told they were in litigation with, was that litigation with Medical Center Bowling Green over there? Or was it some other renter that you didn't know?
It was, and I'm blanking on the name, it was FTTH in the, but what, we had a hurricane that hit our facility there, and we had some insurance dispute, and that's where we were dealing. I'm so sorry. I'm sorry, but Your Honor, and so we were involved with that. And so when they said, April has this case and she's in settlement negotiations, and these are facts that, Your Honor,
They were mistaken about which case.
they were one, and then within less than 30 days.
Who was this said that you were in negotiation?
My client told my colleague in Pittsburgh that April's got this under control. She's got settlement negotiations going on, and they had previously talked about settlements. And when we talk about this,
I had.
Who was representing the other party that was suing Bowling Green? Who was representing? Was your company? So you were in negotiation with a different law firm over settlement of the case down there, and had nothing to do with this.
And
Is that
again,
right?
to do absolutely, Your Honor, absolutely, Your Honor. And then we're talking again, I go, as soon as I found out, and this is a 30-day lag, as soon as I found out, I filed an answer within 24 hours, waived service for 2 defendants. I wasn't even going to fight about these services, 2 defendants. And I reached out and I said, and again, I said, this is what happened. I apologize. You'll have a settlement from me in shortly.
Do you have everybody, did you have everybody served?
Did not have everybody served. I did have 2 of the defendants we only moved for default judgment against the 2 defendants.
You have the other party served?
I think we did.
No, Your Honor, but I filed an answer and I waived service for both of those. But then our answer was stricken.
Well, let me ask you something. If your judgment stands against 2 parties that get served, and it doesn't stand against the other 2 people who aren't served, I guess you would remove the motion for default judgment then, but she made an appearance before you file such a motion. Follow what I'm saying?
I did. I understand what you're
Okay, so how would you divide the damages that you should correct between the people who do have a default judgment against and the ones you don't?
saying? They are jointly, severally liable for contracts.
So what
They
the
all,
contract
the contract does, there was an assignment of the contract. We agreed, but we didn't release any money.
And Your Honor, and this is where, again, the standard here is, was there a mistake? And Your Honor, I'm not arguing that it was a mistake. There certainly was a mistake. It was a short mistake and then with meritorious defense. I will, Your Honor, I'm prepared today to
Well, just
argue
for
the
this-
facts.
for the, or just for the sake of, what defenses do you have?
Multiple, Your Honor. Okay, so there are 4 defendants in this case. If you could look at the actual agreement, there's only one party that signs this contract. Only one defendant signed this contract. Later, the defendant was attempting to sell this facility. In doing so, they said, and with that they had to exchange, and again, goes to why Philly this is above my brain
So
level.
the only,
So-
wait, the only defense that you have up to this juncture is that you're trying to get.
Absolutely not. Your Honor, I have 4 defenses, four meritorious defenses, please.
Well, take what I'm interested in. I'm not interested in your people trying to weasel out of the contract, but I'm interested in is saying why should.
Okay, so then this isn't on the record, but so what happened, Your Honor, with regards to this facility specifically? The regulations changed. They did, and they have told I believe it was us, but I believe it were in the press, it said the regulations changed. We cannot operate this facility anymore. And again, this is a medical facility. They are across the country.
Was
and they-
this a rehabilitation, drugs rehabilitation, is that what you're saying?
Yes, and the regulations change. And Your Honor, and this is where I go to, in terms of, there was this contemplated in the agreement of what happens.
Clause or something that lets
To
them
do,
out.
and that, I'm gonna argue that, I'm gonna argue multiple things that because this facility couldn't operate, there are provisions in the contract that allow them to operate. And the second,
Turn to one of those.
okay, Your Honor, 19.11. And I'm prepared, Your Honor, that,
I can't follow, you're smarter than I am.
that's not true, Your Honor.
Talk faster. I'm just asking simple questions. Look at 19.1 and tell me how that.
Your Honor, okay, so it talks about what happens. It is the intent of the landlord and tenant in entering into this lease to comply with all state and federal statutes and regulations applicable to this lease. The amount to be paid to the lessor as compensation for rental space has been determined, this is my debate, sorry, I'm trying to go, that's it. But determined to be fair market value in the event that the agency, state or federal government having jurisdiction over such matters, such determined that the compensation provided herein does not equal fair market value for services provided, then the lease shall be deemed amended to be provided for payment of compensation in an amount equal to the amount determined by such agency, and it goes on. That, Your Honor, provides me with the, and again, when we talk about then what happened to the facility, that's my probably number 1. But then yes, Your Honor, you hit it on the head. The second is force majeure. The third is that there hasn't been an attempt to re-let the buildings. And I would actually argue in terms of the acceleration clause, it wasn't a close. Cover, yes, Your Honor, it's covered. And then I would actually argue that the re-acceleration clause wasn't included in the amendments. So I believe, Your Honor, I truly believe that there's multiple meritorious defenses. And that's all I'm asking, Your Honor, is to give us a chance to argue on the merits. There was a very small time of mistake. As soon as I recognized that mistake, I contacted counsel. Again, this case has to go on because there are still 2 defendants. It is an interlocutory order. We're still going to be arguing these facts.
Well, they got determined that the 2 things that are left, not in pockets, they don't want to fool with you.
They may, Your Honor.
Yeah,
And
if they did that, you know.
And they can dismiss those cases, and then that other case would become final, and then we would certainly do it. But we are here, and we are prepared to.
Are you represent, are you on Candy here? Is that what you are?
Well, my hope is this case will.
I've never been called that
Well,
before.
I thought it would be a new experience for you, but are you, what, I mean, all seriousness, you represent one or two of these people?
We represent the same clients.
Okay,
We've been retained as well.
So the reason I said that, just said pocket plan, that's what they used to say. Okay, you wanna move over, council, this way.
Judge,
Now, Mr. English, how do you, you practice law maybe one year more than I have, something like that. Maybe not as long, I don't know.
No, sir, not as long.
Yeah, I don't think so. You're a very young guy. Is it your usual practice if somebody misses a day like this and they're like 10 days over and they're calling, you got a break?
If they call me, if they say we need some more time, if I haven't reached out to them and said, we've got this lawsuit going on, if there is, Judge, I don't want to put any lawyer in an awkward position. I just don't. But
That's why we all have insurance. you know,
Yes, sir.
We all have insurance like that. I'm kind of more concerned about any arguments that would happen that would extinguish it in any way that would put your client in a situation where they're being unjustly enriched because they would have an obligation to cover or do other things that people are. Do you think your client would have had an obligation to cover in this case and lease the property with a reasonably reduced rate to ameliorate their damages?
my client has an obligation to act in a commercially reasonable manner. The agreement that was signed with Journey Pure does have an acceleration clause that if the lease is breached and it's not,
Would that negate any obligation to cover it that you might have?
I think the parties are bound by the terms of the agreement.
Well, I understand you think that, I do too. Parties are bound by the terms of agreement. I'm just asking if there is any liberal interpretation where you like to look at that and see that under any kind of business law or case law that exists, that your client would have an obligation to cover.
I think that if they were able to lease the property at
What level of effort should they be required to seek to lease? the
a
property?
commercially reasonable
That's right.
effort.
When I first came back years ago, when the former person told us to do, that's how we done it. And I brought up a gap filler clause in contract. Commercial code. Which part of the form is that judicial district didn't operate under the form commercial code, they operated as a protected business act. And that actually deciding more. So, I think what I see. Excuse me, I got a J call. Yes, sir. No, it's not. No, it's not, that's not right. It's about 30 feet over there. I wouldn't know. Yeah. We'll do it on the years. Try before. I just, you know, I don't know. This kind of goes against my nature. You want to come back over. You want to let your Monticello council get involved.
Well, I hope he takes over. That's the point, but
Good job. You did a good job. Yeah, I understand what you're doing. You're very capable. I don't know, it puts me, it's a tough situation. You know.
And I
But
understand.
I don't know, it's not your fault that somebody else told somebody that you were taking care of the case. It's not your fault. You're not involved. I understand. You probably were taking care of what you were supposed to. And somebody else just received this information. They thought it was talking about this thing here too. They probably thought that Albany and Bowling Green were.
My
same
clients
county.
are ready to testify and they will come here and that they will talk. And then I would ask for an evidentiary
Talk
hearing.
about what?
Their mistake, why they made a mistake, and what exactly happened. Because we do believe, Your Honor, that we fit the rule in terms of what happened in the mistake. And
What rule is that?
And this is the part where I was a little bit, so, Your Honor, because we have two kind of motions of it. One is that all answers got struck. So all four of my clients' answers got struck, but only two were served. And,
I can do that.
yeah, okay, thank you,
You
Your
didn't have
Honor.
anybody in front of the court, you couldn't get a apology. Do you agree with that? I
do.
Okay, and you said you've already come.
Great, perfect. And so then, Your Honor, with regards to where we are in terms of the rules. CR 60.02 is on a motion, a court may, upon such terms to the relief, the party legal representation from a final judgment order or proceeding where there was this mistake, advertence, surprise, or excusable neglect. And again, I would argue that this is mistake. And then my things that I have to show are whether there was a valid excuse for the default. And again, I'm prepared, Your Honor, to get. And then the second is whether there's a meritorious defense. And the third is absence of prejudice to the other party. And Your Honor.
Of course, you're gonna lose absence of prejudice.
But Your Honor, actually, I've put in there a lot of the case law that says just a delay in time does not put the prejudice. That's not what it would be. And again, in all my cases are very clear on the Court of Appeals and that the time span that happened here. The complaint was filed June 21st. Two defendants were served June 21st. The default was July 26th. And then the hearing was August 10th. And we filed and because there was no order on the docket, or I would have made a different argument.
Any order on the docket because it's my staff law.
No, and I understand. I'm just saying I didn't know.
I would not enter because I didn't want to enter a blank order or amount of judgment against someone in default to their prejudice. You understand?
No, absolutely, but that's why I didn't file I filed the answer. I would have made a different argument, but I filed the answer on August 23rd. So, I mean, between service and us filing the
When was
answer,
service on the two?
June 21st.
And so you waited 2 months to August something before you filed anything.
I found out August 22nd. And look at- So,
Your people already knew they had been served. They just didn't inform you, you need to do defense.
to do,
Is that right?
no, and actually, Your Honor, I would not.
Now, wait now, here's, somebody told, somebody knew they'd been served because they inquired and were told that you were taking care of it when they were talking about the wrong case, so they knew they had been served.
To do, yes, Your Honor, and they believe that there were settlements, and just as we said, if there were settlement negotiations, nobody wants to waste away money. And that is truly what we, in my practice, and that is what we do, is that we're all sitting here, let's not run to court. If we can resolve a matter, let's not
But
push
there
this
wasn't
into,
settlement negotiations on the case.
Which
They
is
talked to
the
you about wrong case.
it was the
So
mistake.
it
in which,
appeared to me that your firm is clear on the thing because you weren't involved. They didn't ever give you notice to file the answer.
and they would, if we had come down here, Your Honor, my clients will testify that they made a mistake.
Here's what I just, in my mind, I have, because of the complexity of things that are going on in the world, sometimes I have a tendency to give leeway to legal firms in mistakes because of unusual situation. This has nothing to do with you firm missing anything. You weren't informed that this litigation was going on, as you were working on a different case. And these people were served, and they get that information to somebody. And they didn't get their action file for 60 or 70 days after they've been served. Now, the purpose of the default judgment statute is exactly for people not filing answers. And now what you're saying that you fall under some mistake situations in the rules. Now, you file, I don't have it here, but you filed a brief.
Yes, sir.
Saying that you replied to her brief. I have on the mistake. Okay. Well, I'll take a look at it, but I do want you to submit the judgment, setting aside the judgment against the two entities that have not been served. I'll do something. Okay. I'll do that. I don't think you doubt about that. Lance, you have anything you want to add?
Judge,
I've enjoyed you in this case for
have not had to listen to it, but you may have screwed up. All I would say is if you look at the case law on this, and oftentimes I'm on the other side of this. In fact, I think all my default judgments have been set aside by courts everywhere because of the way the rule is written and the leniency that if there is an excusable neglect, it would be the standard is an excusable neglect. I realize you got to meet those, but I think you have two different litigations going on. And when you mentioned excusing that this wasn't Greenbaum's fault, but also you have to then look at, though, in that situation, the attorney's neglect is, in my view, less understandable because they're knowledgeable of these terms and of these rules and the importance of these rules, where the client may not have understood that and may not have understood
the agent for service process in here somewhere. In every agent for service process that I've ever dealt with, when I still lived in Louisville for a little while, and we used some people that do that sort of thing, or other places, they're very diligent in telling people after they've been served that an answer needs to be. And that's probably the people that were requiring this for an answer to be served. And somebody says, well, maybe it was working on this thing. But the thing that bothers me about it, I don't know what the involvement of the Greenbaum firm was. I mean, they were, I guess, representing these four clients on everything that they defaulted on, based upon this change in the law or whatever that made it not feasible, or change in their business that made it not feasible. So that's the reason your name was brought up. Is that a fair assessment that y'all represent these four groups in other litigation and they got mixed up as to which litigation?
I can supplement with an affidavit if it would help, Your Honor, but the way I understand it, and they may know better because I wasn't in part of that conversation, but I do believe that there are Philadelphia, Pennsylvania, part has helped them across the country with regulatory
So
matters.
you have a branch.
To do, yes, and they help with regulatory, and then I was involved with the, I know, and I was involved with.
So you got a branch up in Philadelphia that was representing these four defendants in other litigation they had when they were pulling back and trying to get back on some of these leases. And one of those was in Boulder. Was it who you said it was in Boulder?
And that, the facts are a little different. So, and I apologize. So,
Was there another piece of litigation going on in Kentucky that your firm was representing these four defendants?
I was dealing, but it wasn't with regards to pulling back. We still operate that facility in Bowling Green. But yes.
I didn't ask you about it. Okay.
But that's why I just wanted to make sure, because I didn't want Your Honor to feel like it was misrepresented. I want to make sure of the facts.
I want to know how this confusion took place.
It is confusing though, right?
It's not confusing me.
Okay.
Don't answer my question. You can't advocate to me. I know what I want to know, and you don't know what I want to know. So if you'll answer my question. we'll
I was in
get a lot
Bowling
simpler.
Green.
Okay. The firm of Denton, Bingham, and Greenbaum LLP was representing some or all of these four defendants in another piece of litigation in Kentucky, yes or no?
Yes,
And you were the person in the firm that was assigned to represent these defendants in that piece of litigation.
yes,
And someone inquired about this piece of litigation here in Clinton County. And they were informed that you were involved in negotiations to try to settle the case, but they got the cases mixed up. It wasn't the one in Bowling Green, it was the one here in Clinton County, and you weren't involved in it.
correct.
Therefore, they allowed the time to lapse when an entry should be filed. And it lapsed over 60-something days before you found out that a judgment had been entered, because you checked here and found out no judgment had been entered in the time. And then when it was entered, you immediately came in and tried to file an answer and file a motion for leave. And you filed a motion to strike their pleadings, which I signed. Okay, is that a good thing? So that's simple enough that even I can understand. Okay,
Can I add one fact to the confusion there, Judge?
I'm not confused now.
Maybe I am, but one thing that will explain it, I'm talking about the confusion with our clients, is that this hospital is owned by the Bowling Green Hospital.
Well, that's the reason I asked early on if the Bowling Green Medical Center was the plaintiff in the other case, and you said it was. So the only thing that could cause any confusion on behalf of your clients would have been that the other lawsuit was going on in Bowling Green, and this had Bowling Green Medical Center as, the medical center at Clinton County. But I don't see where Bowling Green Medical Center is mentioned as party.
No, and
So
that's.
I don't see how that's what I'm getting at. That confusion would not have been there, although it is a wholly owned subsidiary. Is that what it is?
But Mr. Clark, who they were confused, is not a litigator. He doesn't.
Is he a lawyer?
He's a corporate attorney. Yes, he's a lawyer.
Where's he located?
In Philadelphia.
In other words, he's a Philadelphia lawyer. Are they held to higher standards? Okay, I think I've got all of it. Do you have anything else?
Just judge that if you look at the cases that Ms. Winberg cited, the emphasis that most of the Court of Appeals looks at is on those last two, is on the prejudice.
The only problem is that I've been watching suits lately.
Well, that would be,
it's pretty rough. It's pretty rough right now.
But they've lost no defenses, they've lost no witnesses, nothing has changed about what would be litigated in this case over the 60 days. Well, I know, but that's the standard, is are they prejudiced by the delay is the question.
You trying to negotiate with the medical center at Bowling Green?
So in Warren County or?
No, in this
Oh,
case.
yeah. Unfortunately, we got a default judgment to go against.
That's makes a different starting point.
It's a very hard
but
start.
The medical center at Clinton County is the one you're negotiating with. And I would assume that to avoid the pain of trying to go through the Court of Appeals on whether I'm right or wrong, and I stay with it, or whether or not what the amount of judgment there, or whether I ignored whether they had some kind of obligation, whatever. I would suggest that you sit down and negotiate with them. And I'm kind of slow to enter orders sometimes. It takes me a while for my staff lawyer to tell me what I believe. And you're not really interested in getting involved in this much. Okay, she can. So she doesn't want to get involved in it. She's recusing herself from it on the record. So she doesn't want to get involved in it. So there you go. So it's going to take me longer because I keep bidding on her to do this. Okay, so would you like to try to seek somebody for mediation? Or
Yes, I'd be happy to do that.
And there are a lot of great people in Louisville that can do it.
Would be happy to use somebody in Louisville.
Somebody in Louisville.
No, and I'm involved in it all the time.
Well, don't deny Mr. Ingles the opportunity to Epicurean taste. Find a fine restaurant up there. Stay at a fine hotel, although they got great places in Bowling Green. So let's just give you a little time while my old law partner, Jim Turner, may he rest in peace, who you knew. And when I was in the Senate, things, I said, it was one of my favorite terms. Instant coffee ruined the world. That people just don't let things percolate sometimes, okay? So see if y'all can settle this thing and get a reasonable amount of money to compensate you. And of course, you got Justice Minton that's doing mediation.
Justice Hughes.
Yeah, well, I'd rather y'all agree to something. And they got business sports up in Louisville, don't they now?
Yeah.
Business sports, and after you've been in front of me, you understand why they have this. Yeah, people that do this frequently. I don't really get the opportunity to think about these things like that very much. So thank y'all very much for your time. And you give me
I'll do
circulate one of those two parties.
I will.
Then I will reschedule this for y'all, once y'all renotice it to come back. Is November 2nd too quick for y'all to come back on this?
Give us a little bit.
December the 7th?
December
Is that
7th.
Pearl
That should
Harbor
give
Day?
us plenty of time to try to get.
Is that Pearl Harbor Day? December 7th?
It is.
I'll let your class know something up there. Okay.
What time would that be, Judge?
Well, at what time?
1:30.
1:30.
Thank you.
Thank you very much.
That concludes my business.
Yeah, I'm George. Thank you very much. Thank you.
Judge, there was a Monroe Circuit Court case that you had, it was Hollingsworth versus Asher, that you suggested that if Mr. Davenport and I could not get along, we're getting along. So you don't need to hear about that. I just didn't want you to wait.
Yeah,
For
it had the potential of not going.
Well, we're progressive.
Thank you very much. And you have something?
Yes, Your Honor. Well, we just reached an agreement
Well, God bless you.
as to what this report would include. And we wanted to make sure you put it on the record. Steve.
Okay. Mr. Cross? Okay. Mr. Cross?
Recite that, Ms. Fields and
You're going to come up here a second.
Gary, come listen to this.
So, Your Honor, one of the things that
Let's just make the recitation simple.
certainly,
What you agreed to.
I was going to go ahead and recite it. One of the things that we had talked about is that we were going to go back and put it into writing and put it on it.
We will, but right now I want to get everybody together on what it is, so we won't have a disagreement on what it is. You just recite what it is, and
Certainly.
I'll reduce it and I'll sign the order. I know it's not enforceable, but it's a signed order.
So, Your Honor, we were going to have I was using the word conservator. I believe that was at the court selection, who was going to be provided weekly reports from both J3 Packaging. I apologize, biweekly reports. So every 2 weeks. Biweekly reports from both J3 Packaging LLC and Dale Hollow Charcoal LLC. And these biweekly reports were going to include an itemization of the company's expenditures for each 2-week period, which would include A, payroll report, B, raw material report, C, utility report, D, a maintenance expense, E, equipment expenses, F, land cost and associated expenses, G, taxes, and H, any other expenditure not previously identified. And also other aspect of that would be a biweekly receivable report, including the date of the sale, the amount of the goods sold, the quantity / units of the goods sold, the payment terms, and this is E, any other receivables not previously identified in that report. We're also going to have an initial report as well to the ombudsman to get them familiarized with the items of J3 Packaging and Dale Hollow Charcoal. And that would include a full itemization of the current assets and liabilities of the two entities. And then we were also going to have within those biweekly reports to the conservator that on the addition or subtraction of any customers of either J3 Packaging LLC or Dale Hollow Charcoal. And then we were going to have the conservator report to the court in the event of any disagreement between the parties or transfers that identify the lack of proper business necessity.
That's what we've agreed to, Your Honor. Everything is bi-weekly instead of weekly. I think we probably ought to raise one point here. I don't know who the court will find to serve in this. There's a person or two around that we would object to. I think you probably know who they would be.
There also needs to be a provision, cost,
Yes.
cost that would be taxes, it's cost.
Yes.
With each party being obligated. So,
Have to add out the corporate funds, I suppose would be.
Your Honor, that was our understanding, is that it can be taxable to the company. But I do agree with you that it's taxable as a bill of cost.
I just make a suggestion to find somebody to run it by Mr. Wallingford and I and see if we have any issue.
Well, it won't be local attorney.
Okay.
Is there anyone other than that?
I don't want Ms. Thomas. I found her. Other than that,
I wouldn't do that.
Mental note of
I wouldn't
Mrs.
want to
Thomas.
You don't think much of him. Okay, I'll try to find somebody. Has some knowledge of industry and some business background. And I also will negotiate a reasonable cost.
Your Honor, I appreciate that. I think one other thing that my client requested that I add is the emphasis that he does believe in the continued viability of Dale Hollow Charcoal as a business operation, and believes that
Well,
it could be
there's
successful.
liability, it just might be something he doesn't need to be involved in. You know what I mean? That's a decision for y'all to make.
Yes, I understand that.
But I will tell you that once these sort of, it's hard, and I'll just make this as a general statement. It's hard after you impugn someone, or after you feel someone has disrespected you, as far as money, it's hard to work together after that. And so that, it's just hard. And some people can get over it, be difficult about forgiving things. But I've always found that portion of the New Testament is an aspiration when it comes to business matters. Not very practical. So it could be that we need to have someone sit down and do a mediation sometime about taking care of how much is invested, how much it is valuable, what's it worth, or somebody just want to get back out of it, what they put in it, that sort of thing. I think it's time to start thinking about that. And as you heard from me, trying to understand the previous case, I'm not a business court judge. I don't know a lot of, I think I understand some things, but I understand people very well. Sometimes it's time to be on the way of choice. So just the word to the
Thank you, Your Honor. Appreciate your time.
very much. Okay, we have a short recess. There it is. Commonwealth versus Harvard, is that correct?
Yes, Your Honor. Harvard and Perry.
This is 22 CR 0034 and 39. 22 CR 35. 38. What do you need there? Chair. Yeah. Y'all just roll one down there. Just Can you get it around that way?
I can't do it.
Okay. Y'all have eyes. I don't. This is a hearing on 404B, is that correct?
Yes, Your Honor.
And do these two committees have separate counsel? Mr. Cross, you represent.
Ms. Fields and I represent Ms. Harbor. Ms. Harbor.
You represent Mr. Parrish.
Yes, Your Honor.
Now, does this 404B information, Mr. Commonwealth Attorney, affect both parties, or is it?
Well, I intend, if the court allows, to try both parties at the same time.
And the reason I asked that
Yes.
is, should I say that this 404B evidence is admissible, it might be necessary to try them separately.
I agree that's possible. Because I think most of the 404B evidence goes against Ms. Harbor, if not all. And most of the factual allegations at trial, as far as the infant's death, probably go against Mr. Perigin, because he was the one, according to the witness, laying on the child. So it's a convoluted situation.
Okay, you wanna bring your evidence in?
Yes, and I'll go ahead and call Heather Phillips first.
Heather Phillips? You raise your right hand and swear the testimony that you're about to give us the truth. And then you sit down in the chair and toward the little red light box there. State your name.
Heather Phillips.
Ms. Phillips, where do you reside?
I was out in Berks County, Sherwood Shores.
Okay, and do you know either Haley Harbor or Cody Perigin?
I know Haley Harbor. I don't too much.
Border box. Speak out loud.
And how long have you known her?
I have known her for, I'd say at least 5 years.
Okay, and let me ask you, were you familiar with Miss Harbor and her children?
Yes,
And you remember the baby Elena Harbor?
yes.
Okay. Now, did you assist, the child passed away either on April the 14th or the morning of April the 15th of 22. Did you assist Miss Harbor in any way as far as trying to help take care of that child when she obtained physical custody and legal custody of that child?
Yes.
Did you tell the court what you did?
I mainly helped her with her house, bringing stuff over for the baby.
Okay, and you remember where the house was located?
Yes.
Could you tell us, please?
It is I'm not too familiar with Albany.
Okay.
But I think it's not far from the Pizza Hut.
Okay.
And yeah,
And what did you do as far as, did you donate her furniture, help her get furniture? What did you do?
it's always furniture that she had already got. I guess her and Trevor had got, and I had picked up at Debbie Moses' house.
Okay. And the house that she was in at that time, could you describe it as far as the interior, how many rooms it had?
I think it had 3 rooms, and it was really bad shape.
Okay. And what type of furniture did she have in there for herself or for the infant child?
So there was a futon and a playpen.
Okay. And did she have other children that were using the playpen?
Yes, she had 1 toddler son.
Okay. Now, was you over there, you were there the night that you found Elena on the futon, is that correct?
Yes.
And were you there the night before?
Yes.
Previous night? Okay. And why were you there that night?
I was bringing her furniture over that night, that
Okay.
first night.
Okay. Now, the second night you were there, do you recall how long you were there?
Second night, well, my plans were just to help her clean, but we got stuck in her front yard, so we ended up having to stay the night.
Okay. And what kind of activity was going on at that residence that night?
There was using marijuana. Well, she was.
Okay. Was there other people at the residence?
That night, it was just her and Cody and me and, at the time, my fiance, Joseph Paul.
Okay. And was there, the night before you were there, was there a lot of people at the residence?
Yes, but now I don't recall their names. I don't know them.
About how many people were there?
I said there were probably about 5.
Were they men or women? Or
They were
both?
men.
And you saw her using marijuana the night that the child died, is that correct?
Yes.
You remember the amount of consumption or?
No, not really.
Okay. And were you sleeping in the house?
No,
Where were you staying?
I was staying in my van that was outside.
Now, after the child passed and later that year, did Miss Harbor attempt to contact you?
Yes.
And what happened?
Her and Jesse had came to the place I was staying at and had caused drama there and asked me to go down to the Cove Creek, to meet with, I guess there was some other people that were involved in it.
Okay. And did you go?
No,
And what was her reaction?
she didn't like it. She didn't.
Did she get mad at you?
Yes.
I've got nothing further from this witness.
Yes, Judge. We have a few cross-examination questions. I apologize. We have a few questions for Ms. Phillips as well. Ms. Phillips, what is your relationship to Haley Harbor?
I have no relationship to Haley. It's Trevor that I'm related to.
Okay, what is your relation to Trevor?
He's my first cousin. His mother's my aunt.
So you noted in your testimony that there was a futon and a playpen in the house.
Yes.
Would it be fair to say that you were concerned about this lack of furniture in the house?
You're
I was,
right.
but
I'm gonna object. I don't see how that's relevant, whether she's concerned or not. She had no legal duty to the child.
Well, Judge,
I mean, it's a 404B. I mean, it's about the prior bad acts. It's not about her state of mind.
Judge, I think my next question will point to irrelevance if I could ask it. Did you ever discuss with Ms. Harbor the lack of furniture in the house?
I say it's my responsibility, ma'am.
So the night of the infant's death, how did you know that Ms. Harbor was smoking marijuana as opposed to, say, tobacco?
Well, she smoked it out of a big bong.
Okay. Were you smoking it with her?
No, I was not.
Okay. Was Trevor Moles smoking it with her?
Trevor Moles was in jail.
Okay. I don't have any further questions, Judge.
May I proceed? Ms. Phillips, I think you talked about Ms. Harbor smoking marijuana.
Yes.
Didn't even say anything about Cody.
Yeah, I did not see him smoking it.
And you yourself mentioned you weren't smoking that night.
No.
Were you using any drugs that night?
No.
Drinking?
No.
Thank you, ma'am. Those are all the questions I have.
This representative should be released.
Yes, I don't know if the court needs any further context about how she found the child and the defendants or not, but I'm finished as far as the 404B goes. Because I think the rest are direct observation.
That night.
Yeah. Yes, that's all I have.
Maybe released.
I would, if she doesn't mind staying, I would like to go ahead after this hearing and get a trial date and go ahead and get her served with subpoena since she lives out of state. And that saved us a lot of trouble. She probably needs to go back if I don't get the approval on witnesses.
Okay, we should go back to the room, wait, and call that out.
Oh, yeah, please, sir.
You got something ready?
Yes. Whatever, you just needed that.
You're in this. So I just want that to get the truth. And the truth. So, take a seat there, lean toward the back black box in front of you, with the light on there, see? And state your full name.
Middle name too.
You need to speak it out loud.
Deborah May Fitzgerald.
Okay, and lean toward that box there. So,
Yeah.
Mr. Shockey, you may proceed.
Ms. Fitzgerald, you're Trevor Moses' mother, is that correct?
Correct.
Now, how many children has he and Miss Harbor had?
They have 4.
Okay, and one of them's deceased, is that correct?
Correct.
And that leaves 3 other children. What's their names?
Correct. Raylan, Caden, and Cannon
And who are those children staying with now?
with me.
Okay. Now, did Miss Harbor and Mr. Moles live with you anytime after they started residing together or were married, having these children?
Yes.
Okay. And your residence is here in Clinton County?
Correct.
Now, I want to ask you about the latter part of March, April, I think.
You said Miss Harbor.
Trevor Moles, M-O-L-E-S. He is the father of Miss Harbor and his children. And the deceased child was his daughter.
Biological child, and Mr. Perry was her parent.
He was there that night when the child died. Yes.
Was he there? Passing out like.
Well, you'd have to ask the defendants that.
She knows that or what?
No, no, yeah. So, I want to go back to the latter part of March, first part of April, okay? Now, during that, well, let's take it back a little farther. You remember when Elena was born?
Yes.
You remember her date of birth?
December 15th of 2020.
Okay, and
That's the deceased child.
that's the deceased child. And then she was deceased on April 15th of the next year, is that
April
correct?
14th.
April 14th.
Yes.
So she lived approximately 4 months.
Yes.
Okay. During that time that she lived, where did she mainly stay?
She was in UK hospital for a while, and then when she came home, she came to my house.
Okay.
to stay.
When she was, would it be fair to say she stayed at UK hospital about as much as she stayed at your house?
Oh, yeah, more.
Okay. Now, did she reside, did the child reside any other place other than those 2 places up until the last couple of nights?
No.
Okay. Now, at some point in time in April, you believe that Mr. Moles lost his employment in Tennessee because of actions Ms. Harbor took. Is that right?
Yes.
You know why? What she did because he loses his employment?
She made accusations that he.
I'm not
shot a
hearing
gun
what she's
by her
saying.
head.
You have to speak up a little bit.
She made accusations that he shot a gun by her head.
Your Honor, I think we're going to have to check. This appears to be hearsay unless there's some sort of.
That's fine. I'll skip over it. I've got Mr. Moles here to testify. Okay. It's after that, after she made these accusations, was there a protective order entered
Yes,
by the Clinton District Court?
yes.
Okay. And as a result of that protective order, did Mr. Moles go to jail?
He went to jail that day. He came to court for it, yes.
Okay. And did you and Mr. Moles lose custody of that child as a result of that protective order? Physical custody, legal
Yeah.
custody? Okay.
At the time.
Now, that was entered, and the court can take judicial notice, that was entered April the 5th of that year.
So this is biological mother gets the baby on that day.
Yes, well, she gets a protective order in,
And the protective order gave her the baby.
gave her legal custody. But did she take custody of the child right away?
Not right off. It was kind of back and forth.
Okay, and when you say back and forth, can you describe that to the court?
I had part of them, and some of her relatives had part of them, and that evening, I took the baby and Cannon and Raylan back. And then later that evening, I got Raylan back, and then Cannon and Elena, the baby, were left with her that night.
You're talking the night that Elena.
Like that Elena passed away.
Okay, But between April the 5th and April the 14th, did Elena and the other children stay with you?
No, they did with me, yes.
Okay. And about how many days before that she passed did Miss Harbor get the children?
She got them that day. I took them back that morning because my daughter was going to get them that
So
evening.
you're saying the day of April the 14th?
Yeah, yeah.
Okay. And in that afternoon, that later, you picked up the 3 oldest ones. Is that right?
Yes,
You tried to get the baby too,
yes,
but Miss Harbor kept the baby.
yes, and Cannon.
Okay. Now, after the EPO was entered on April the 5th, did Miss Harbor stay at your house
Yes.
between April the 5th and April the 14th?
Yes.
You remember how many nights? If you know.
Probably most of them.
Okay. And was that with your permission or without it?
Without it, I didn't prove of it, but
Okay. And she didn't break in, or did she sneak in, or how did she get
she
in?
came through the basement door.
Okay. Is that where Mr. Mole stayed?
No, we stayed upstairs, but it was open.
Okay. Did you hear any altercations between her or Mr. Moles or the baby while she was staying during that period of time?
Well, I heard her screaming at the baby to shut the F up,
Okay.
but it was crying a lot. She was crying a lot. She was in there.
Okay. Now, also, was there an issue about Elena coming home after the EPO was issued and about the hospital at UK?
Yeah, yeah.
So-
Her great aunt told me that DCS was gonna take the kids if they didn't pick Elena up from the hospital. And when I tried to call the hospital about picking her up, they told me that I was not allowed to and that my son wasn't allowed to. So they couldn't
How
give me
was
any
the-
information.
Do you know how the child was picked up at the hospital?
Haley and Trevor.
Went and picked her up? Okay. Now, according to the notes you furnished me when Miss Harbor was making statements telling the child to shut up from crying, that was on that night of April the 11th. Is that correct?
Probably, yeah. I've seen
Okay.
this before.
Now, on April the 13th, did you receive a text from Miss Harbor that that the other 3 children, you were going to get them back because she didn't have any food?
Yeah, she wanted to know if I could give her a ride to the store because I didn't have any food. And
did you do that?
I did.
Okay. And did you take possession of the children at that time?
I got Raylan back.
Okay.
And Cannon and Elena was left there.
Had you ever seen Mr. Moles perform any kind of acts of violence toward Miss Harbor?
No.
Okay. Okay. I have nothing further to comment.
Judge, I have some questions for Ms. Fitzgerald. So Ms. Fitzgerald, in relation to the EPO that was taken out against Trevor, is it your allegation that Ms. Harbor lied or perjured herself to get that EPO?
Well, it happened. It was supposed to be in my home. I was there. Nothing like that happened.
Okay. How often were you around Haley and Trevor during this time period, around the time that the EPO was sought?
What? They lived in my home.
Okay. And were you there the day that this event allegedly happened?
Yes.
Do you know if Trevor owns a firearm?
He always has.
So regarding Trevor's employer, who was Trevor's employer at this time, at the time that Ms. Harbor allegedly falsified statements to the employer?
Hutchinson's and Livingston.
How long had he worked there?
I don't remember exactly. I'm not sure.
And can you specify again what the false statements were that Ms. Harbor allegedly made to his employer?
That he had shot a gun at her or something like that. Or
And
by her head, I don't remember exactly.
are you aware of any disciplinary record that Trevor had at this job?
No.
So regarding the, your allegation that Miss Harbor, if I understood it correctly, kind of busted into the doors of the basement of your home, is that correct?
She came into my home through the basement. Correct.
Okay. Was she living there at the time?
She wasn't at that time because she was supposed to be around my son.
Okay. Did you call the police when she came, knowing that she had violated the EPO that she took out?
I made everybody leave.
Okay. If you knew that she was, if you believe that she's trespassing on your property,
I don't understand.
Your Honor,
I'm kind of lost.
the theory of my case is this. If it'll help the court, I'll interrupt and tell you. The theory of my case is this child spent the majority or half of her time at the neonatal unit of our UK.
Rest with this way.
Rest with this way. Ms. Harbor went and took out EPO on April 5th. I watched the hearing. Mr. Knowles was not represented. Judge Lawson had the hearing. And I don't think he ever made an admission that he did any of these things. Judge Lawson entered the EPO with transferred custody of Ms. Harbor, who was, I can say, not able to take care of this child, or the child would still be alive. And when that was tested and that was taken out with all these false statements, I've got Mr. Knowles here to testify. She continued to live with Ms. Fitzgerald. And as soon as she moves out, she has all these men down here that she's smoking marijuana. And Heather Phillips comes in and Cody Perkins laying on a dead child. Now, that's basically our case. And I think the jury deserves some context as to what happened in this case.
Well, I don't know whether this is really 404B.
I know the marijuana is.
Yeah. 404B, it appears to me that contextually, this is relevant anyway in the case, but it's not some of these things that are being talked about. The reason I'm asking here is usually 404B things are other crimes or other bad acts or things like that that we don't. Right now, you're talking about the relevance of this.
I'm saying that the fact that she obtained this EPO through false allegations was a bad act.
Judge, the Commonwealth also alleges in their 404B motion that Ms. Harbor had an instance of forcibly entering Ms. Fitzgerald's home. And we would assume that because they mentioned that in their motion, that we needed to address that because they were seeking to admit that as evidence of a prior bad act.
She testified she went into the basement door to characterize her testimony how you want to, what she just said.
And Your Honor, I'm not trying to double team Mr. Stockton like,
But it doesn't work.
we've got a judicial determination of a domestic violence order. It was entered in April 2022. Mr. Moses was present. He had an opportunity to testify. He had an opportunity to appeal. Now, I don't see how Mr. Stockton can attack this when he was there. And the court has determined that there was an act of domestic violence. I don't know how he can come up and try to assert that it's a lie.
Well, I can play the jury with the tape, and there was no due process. He wasn't represented. There was no admission. And basically, Ms. Harbor wanted the EPO dropped, and Judge Lawson thought he was doing the right thing by keeping it in her. But of course, Judge Lawson didn't know all these facts about the fact that the child was in the hospital all the time. Ms. Fitzgerald took care of him and all this stuff. Yeah, you can try to hide this from the jury and just wax it over. And the reason we got a dead child because it was waxed over and extra cold. It's the most abused EPO I've ever seen in my life. And that's the reason I guess I'm so prejudiced against them when I deal with them, when all these women come up there and want relief. It's because I've seen what happened in this case.
And Judge, insofar as I have a leg to stand on. I think it still has a race judicata effect. I agree with Mr. Cross. This appears to be attempting to relitigate what's already been litigated.
No, but it's never been litigated. There's been a judicial finding, but it's never been litigated.
Judge, as far as I know, there's no entitlement, constitutional entitlement to counsel in this case. Mr. Moles could have obtained counsel and presented his case. He chose not to at this time.
I'm not so sure I agree with you, but people are entitled. That's an issue that I think is in flux as far as whether, you know, how they do each person. And there's you know, it's always bothering me a little bit. The issue is, I don't think that this is really a 404B sort of situation. Because I don't even think it has to be. I think that as far as she's concerned, there was testimony of how she was acting at the time to get custody of the child, and there's testimony that she was involved in the bad act she's involved in, was smoking marijuana and other things, and she was using this procedure here, which, contrary to some of my fellow judges, I do believe that these drugs are quite frequently used appropriately to get custody of children. And in this situation, I think it is a bad act. It can be proven that she fabricated information to get custody of the child, and if she was not capable of taking care of the child, or she was involved in various activities at the time, I think all that's relevant. Now, where that places your client, I don't really think it affects your client. I really don't know what he was doing there that night. Whether he had anything to do with her getting the child or not watching the child or what he was doing, because I don't know anything about this case, which I'm not supposed to. But I am going to rule. I've heard all I need. Do you have anybody else you want to bring up?
Well, Your Honor, it's Mr. Stockton's burden to go forward with this.
Well, I think he's met his burden. I think he's met his burden for context purposes, for people to understand. There are several things in this case that make it different. This mother should have been on notice that this was a high-risk child, with the level of care that was necessary for the child. That she made, according to this testimony, I'd say what he wants to elicit, and I haven't accepted this factual, but it is, that he used various purposes, using various purposes to get control of the child, which she should have known needed special attention. And then she was doped up or something or whatever and didn't take care of the child and let the child end up being smothered by somebody else. So this gets into reckless behavior, want behavior, all those sort of things that could be there. But you can't just bring the jury in blind on whether or not the baby was just there and somebody fell asleep on the baby and smothered it. If that's what happened, I don't know if that's what happened. I know the cause of it.
Judge, if we may, even just to preserve the issue, we understand that each, the items of evidence that the Commonwealth has presented today may be deemed relevant. However, the Commonwealth has to prove all three prongs of the Bell versus Commonwealth test. All three prongs of the test in Bell versus Commonwealth, that the evidence has probative value and that it's not unduly prejudicial.
I understand that.
And we would argue that most of the evidence, if not all presented today, lacks probative value. Any allegations that Ms. Harbor used nefarious means to obtain this EPO, that goes to her honesty. This is not a crime of dishonesty. Any allegations that she may or may not have been using marijuana around the time that the infant child died. I have case law noting that it's presumed that marijuana usage has little probative value to prove other crimes, when the Commonwealth is not alleging that marijuana use directly, it's not a drug crime, or they're not, they haven't charged Ms. Harbor with possession of marijuana. So we would argue that that goes directly to admitting that evidence because doesn't have probative value and is unfairly prejudicial.
Your Honor, there's also some evidence that, as regards to your analysis and the fact that marijuana was consumed may let that in. I don't know that I'm going to pursue that or not. The other thing is, and I agree with Mr. Hunley, just whispered in my ear, and it's part of my motion. Like the court said, all this is inextricably intertwined with what happened the night that child died. You know, it was just a set of events from April the 5th on as to what happened that caused that child's death. This lady should never have had that child unsupervised. She didn't have a proper place for it. She wasn't capable of taking care of it. And I think to her benefit, she even reached out for help to Judge Lawson because she was trying to get the EPO dropped that day. And I can see why Judge Lawson wouldn't drop it because he's skeptical. Here there is an allegation this guy fired a gun at her head. You know, the allegation is so bad itself, whether it's true or not, he was reluctant to drop the EPO.
Yeah, I'm in frequently placed in a situation where EPOs.
But anybody,
But out in abundance of caution, you let them stay until you never hear.
but in this case, it had tragic consequences.
He hadn't had the EPO hearing, it was just an EPO.
It was a hearing and it showed up without counsel. There wasn't any testimony taken.
There was an EPO.
It was introduced to the EPO. Yes, I agree.
Okay, does anybody else have anything else they want to?
Got another witness if I need to call him, if you think the court
What's
says.
the other witness?
Otherwise, Mr. Moles was just going to testify that no, he didn't put a gun to her head. He didn't do these things that she alleges. That's basically the amount of testimony.
And again, we go back to judicial determination of domestic violence. We tender this to the court for its review.
Well, I'd like to see a case that says that the Commonwealth of Kentucky is barred from introducing evidence based on the DDO hearing that finding of fact. I can't refute it in a jury trial in circuit court. I'd like to see case law from that.
Of course, I think that's what the VPO is, the court does. You know,
I think they're great. I just think they're abused.
Yes.
Right. And Mr. Stockton agrees with it.
In
this case,
yeah.
he agrees that it was abused, and what he's doing, not against necessarily this gentleman, the defendant here, he's not, but he's talking about, a bad situation where this mother came and used false testimony to get control of this child when things were going on there. Had the child in there for that reason, should have been mindful and take care of the child. It just shows, I think that these things are in this. So I'm going to rule that. Now, I think that there's a level of that you can get into it. And what I don't really think that you need to go into whether these statements were true or false. Particularly, say, well, you want to prove that she filed a document that was based upon false information in order to get custody, get control of the child. Yeah. And then she might not be, because of that, she might not be truthful concerning what happened with the child. That the truthfulness of veracity concerning this child is what we thought. Is that right?
Well, I'm not much going into the truth and veracity of what happened that night. I think the facts speak for themselves.
Well, I know, but if she gets to the point where she denies.
Well, then I think it can be, above. Because all 404D is just my case in chief. It's not as far as.
Well, I know, but while we're talking about what level of this case might be missed. What do you got to say, Mr. Ross?
I prefer to Ms. Fields. Got a great job.
Anything else you want to say?
I don't have anything off the top of my head unless I can defer back to.
Let me ask you, let's just have a complete statement. Man, you may be excused. Yeah, may be excused. Now, let so there won't be any mistake at the trial. I want you to outline here in front of the court and on the record what the witnesses that are going to bring, what testimony you consider before testimony. So there'll be no misunderstanding that we will not. Okay? Will y'all kind of vacate the microphone?
Yes.
I'll try not to miss it.
Because I think that the very nature of 404 needs to be defined.
Yes.
So we can talk about. So let's go down through it.
I think, first of all, that it's the Commonwealth's contention that by trying to get this EPO under false pretenses, that's a prior bad act, and I'll introduce evidence of that. I also think it's a prior bad act if she made statements cussing at the child because she couldn't take care of the child, and the child was crying. I think that's a prior bad act.
No, no, Mac, I'm sorry, you know how I am. Say that one more
I
time.
said if she made statements cursing at the child when the child was upset, where she lost her temper or whatever, I think that's a prior bad act. I think the usage of the marijuana is a prior bad act. I think all the rest of this stuff about where the child stayed, where she stayed up until the time the child died after the EPO was entered is just for context. It's just all, it's not really bad acts, but it's so the jury will know what was going on for context of what happened. And I think the fact that she tried to talk to Ms. Phillips about the case afterwards might be a subsequent bad act, depending on where that testimony goes. Yes, the first witness, when she said she tried to meet with her and she got upset when she wouldn't meet.
Unless they can show some sort of malevolent purpose in that, Your Honor.
Yeah, I'm a little troubled about that, because we don't know what she wants to talk to about. She was the first witness of the biological father.
Yeah, the problem is, and Jesse Phillips, who's recently incarcerated, threatened, according to Heather Phillips, her, unless she would not change her story. When Ms. Harbor was trying to contact Ms. Phillips, Jesse Phillips was involved in that. So whether he was her agent or not, I don't know, but it bears looking into it.
Sure will.
Yes. So that's the four things I think is prior bad acts or subsequent bad acts. And I don't think any of that goes to Mr. Parrish.
I concur, Your Honor.
But I think if we try them together, it all comes in.
It's the nature of the charging, so I understand, make sure this against Mr. Parrish, is that he fell asleep on the baby and the baby smothered. Is that what
Well,
you're saying?
Heather Phillips' testimony will be that she came back that night. She was worried about Elena. She came back in. She couldn't find Elena in the playpen. And Mr. Parrish and Miss Harbor were on the couch, laying on the couch, and the baby was underneath Mr. Parrish. No, that's her testimony.
It was baby deceased.
Well, yeah, it was blue. If it wasn't deceased, was shortly thereafter.
You have medical testimony given in.
Yes. Don't know how much help that'll be, but I've got a medical examiner. Of course, the medical examiner, no, since the local authorities investigated this case, the KSP didn't do it. Nobody went to the autopsy, law enforcement. So the medical examiner didn't know any of the facts of the case. She initially ruled it Sid's death. Then when she got some of the facts, some of these additional facts, she basically said cause of death undetermined.
Everything else.
It's an interesting set of circumstances and tragic set of circumstances. But I don't think
Those are all in order.
Can we go ahead and set a trial date so I can serve these subpoenas sometime next year? Oh, yeah.
How about February?
That'd be fine. The only days in February I can't do it be the 19th through the 21st. They're the only days I've got marked out.
How about February 26th? 27th.
It'll be fine with me tonight. We got 5:30. Still hungry.
That works for us.